दिए दो normally
नहीं कोई नहीं लगेगा origin set कोई नहीं. I need to mention item number 81 of my lord's list.
This is that trust deed matter, my lord. It really involves that question with regard to interpretation of that deed, which is of 3 pages. My lord, whether the trust survives or not. My lord, this has gone down the list, my lord. And the problem is, I know there is no stay. Your lordship specifically said we are not passing any order of stay. But in both the courts below, before both the courts, my lord, the honorable single judges have adjourned the matter because of the pendency of the appeal.
81.
81. Your lordship's pleasure was that we should come with informal paper books and your lordship would hear out the matter in one day.
What is the name of the cause title?
Choyanendra.
Yes, Choyanendra.
Yes, madam.
Yes, so we can't remember anything. So what do you want? We can't upgrade it, Mr. Gupta. No.
There are 2 grounds of urgency. The buyer.
We'll release it. You get it assigned.
Kindly do not.
No, we can't upgrade.
The last state, my lord, your lordship
heard
the matter.
We are releasing not out of any ill feeling. Get it assigned, have it heard.
No, my lord, your lordship
we can't because in 50% of these matters there is equal urgency. Then we have to upgrade all.
It was appearing as application. My lord, all documents were there. Your lordship's pleasure was that we should come back with an informal.
Maybe, but we'll have to hear the appeal now.
Yes, my lord.
Right.
Yes, and it's really on the question of 3-page document.
That's all very well. We'll happily release it. Tell us.
Kindly do not.
No, my lord, I am appearing on behalf of the appellant. My
lord. Next.
Well, I have appellate mentioning.
Appellate side.
Maybe the leave of Justice Banerjee, may I mention before Justice Rai? Well, there's one matter, serial number 130. I want to withdraw it because I filed the arbitration petition is there.
You are mentioning before Justice Rai.
Yes. My lord, there's one matter, serial number 130 in my lordship's single bench list appellate side. I want to withdraw the matter because there's an arbitration proceeding. I want to go before that. And there's a little urgency in the matter. So if my lordship keep this matter today or any day, because I've come from Bombay, that's the only difficulty, my lord.
Very well, but I'll not be able to sit today. Whenever I sit singly,
my lord, only difficulty is that there is a tender which is going to be on 15th of September. Before that, I have to finish it. I give to pay the money. So lordship, just for withdrawal, my lord, lordship can do it even in court right now.
Give it, we shall see.
Huh?
You give it, we shall see. It can't be done today. You give this list, we shall see. It will appear in the list. Keep a watch on the list.
Well, only thing I have come all the way from Bombay. That's it, my lord.
Withdrawal matter, you need not come. Your advocate.
No, but after withdrawal, I have to file it before the arbitrator. That's the only difficulty. For that,
so very well, you file it after it is withdrawn. But for withdrawal, you don't have to come.
No, not that, my lord. Difficulty is that after I withdraw,
it can't be done today.
No, lordship give it tomorrow. I will
have given it the list. You have given the slip. It will appear in due course. Keep a watch on the list.
But tomorrow can be done, my lord. Only
I don't know. I can't promise.
Yes.
Non-commercial. Item number 1.
Yes. Interim order.
Interim order is still
August.
Till August.
Yes, somebody mentioned that said the advocate on record is going on medical leave, won't be available.
Not opposing it, but could your lordship fix it on any day?
Very well. I have
after he comes back. There's a 2014 decree challenged in 2021, rejected on the ground of delay.
No, is there a stay or any interim order?
Yes, there's a status quo in respect of the property, which I'm enjoying a decree from 2014.
Status quo passed by which court?
The status quo was initially granted by my Lord Justice Mukherjee's division bench because the matter was taken up almost every day.
Yes.
So we came and told the court that because it was going to getting over, we will not deal with the property. So I was appearing. So on that basis, there was a status quo. Then the matter got dismissed for default. 3-4 times they don't appear. Then when your lordship revived the interim order, the matter, restored it, naturally the interim order also got restored.
But factually, I have something to say, but I am not saying anything about their concession, whether they have at all made or not. Lordship can fix a date, Millet. I have no problem. I am ready to argue.
Ligun. Learned advocate, learned senior counsel, appearing for the appellant, says that the appellant's advocate on record will go on medical leave soon. Stop. The interim order that is subsisting will expire after August 31, 2025. Stop. Learned counsel requests for extension of the interim order. Paragraph. Learned counsel appearing for the respondents
Yes, too.
in his usual fairness does not oppose the prayer, but says that an early date should be fixed for hearing of the appeal. Stop. The appeal, the appellant has challenged a decree.
Ex parte decree. Order 9, Rule 13 rejected, my lord. Against that we have come out.
Against that you have come.
Yes.
Has challenged an order rejecting her application for recall of an ex parte decree,
Lordship.
comma, 7 years after the decree was passed. Paragraph, let the interim order that is subsisting stand extended till October 27, 2025 or until further order, whichever is earlier. Paragraph, let the matter be listed under the appropriate, এটা কি appeal from order হবে নাকি? Under the heading appeal from order. When?
Any day, my lord. Lordship can fix a time if the court
No,
finds.
no,
Very
we
well. I leave it
can't.
to your lordship.
On আজ কত তারিখ আজকে?
18.
20. On August 27, amongst the first 5 items.
Very
But
good.
only thing, my lord, দাঁড়ান একটু. Since, my lord, my advocate on record has a medical issue, my lord, she will not be available till, my lord, the end of August. Any
What
day.
stopped you from telling us that before we said? We said when, you said any day.
My lord, any day I thought, I'm sorry, my lord. I'm sorry.
When will she be back?
For
After 10th of September.
Not right.
My 2 items will be getting operated, so it will take 15 weeks.
Oh, did we say October? না interim order অতদিন কেন তাহলে? আমি তো অগস্টে আছি।
Yeah.
End of September.
But your lordship said usual fairness. I couldn't say anything.
End of September.
আরে আপনি চুপ করুন না.
End of September or until further order. হ্যাঁ? কি বুঝেছেন তো? আর ডেটটা ফিক্স করুন তাহলে 10 September. 10 September amongst the first 5 items.
Lordship. My lord said, please.
Yes, I thought we thought we were
Your Lordship, I am appearing for the respondent number 2 in this.
very good.
Respondents.
Grateful, my lord.
Grateful.
Item number 2. May it please the Lordship, my lord. I'm for the appeal. May it please, my lord, I am appealing for the respondent in the matter.
Restoration.
The restoration, my lord, I'll not be opposing. I'll leave it to your Lordship. But may I only indicate
Oh,
this,
এটা দাও।
that we have filed an application, my lord, for deposit of money, which is, my lord, money is deposited around 50 lakhs odd with the registry, my lord,
For withdrawal of that.
for withdrawal of that. But since it is a restoration, I understand, my lord, I'm not standing in the way.
That application also cannot be allowed now since we are restoring the appeal. We'll fix the appeal.
But may I only indicate this, that since, my lord, there was a 34 and from there, my lord, there was a belated 37. My lord, they had filed an application for condonation of delay, which, my lord, was allowed by the Honorable Division Bench. My lord, my clients then preferred an appeal, an SLP, which is pending.
Mr. Bag,
My lord.
let us dispose of the restoration
Indeed.
first. We'll hear you after that.
My-
এসো লেখো। Where is the order? Dismissing your appeal? Which page? আচ্ছা, এই যে,
First time.
24th April.
24th.
This is an application for restoration of APOT 20 of 2023, which was dismissed for default on April 24, 2025. Stop. Paragraph, having heard learned counsel for the parties, we are satisfied with the explanation furnished. For absence of learned advocate for the appellant on the day, the matter was dismissed for default. Paragraph, accordingly, comma, the order dated April 24, 2025, comma, is recalled. Stop. APOT 20 of 2023 is restored to its original file and number. Paragraph, GA 3 of 2025.
This is GA5, Milord.
GA 5.
GA5. GA3 is our application, Milord.
GA4 and 5.
কি দিলে ভাই তাহলে?
But may I also indicate this? GA4 is perhaps misconceived. Milord, GA4 is, Milord, an application for condonation of delay to file the recalling application. Conjoint reading of Article 123 and 137, it's 3 years. So, Milord, I do not know whether
It will stand disposed of, just simply. তাহলে GA 5 disposed of. GA 4 and 5 accordingly stand disposed of. GA 4 and GA 5 accordingly stand disposed of. Yes, now tell us about GA 3 or whatever you want to say.
Milord,
GA3 is, Milord, our application.
they have challenged the earlier section 5 before the Supreme Court. The itself is still not pending, Milord.
It is, Milord. The only difficulty I'm told, because I was not
The
there in the
condonation, you have taken up the condonation before
the condonation, Milord. To the, Milord, section 37, there was a period of delay. The only point of challenge I understand, Milord, is that they had been appearing in the execution petition. But in the appeal, Milord, the ground taken is that due to medical reasons, we could not prefer the section 37.
Only thing, Mr. Bag, the appeal is today again back on file.
In fact, when that's the reason they could not be proceeding, Milord, in the Supreme Court, because then Milord, that matter had become infructuous.
Now you can.
Now they can, Milord. Now they can.
Now this matter is restored, Milord. The Supreme Court is still not pending. That should be disposed of before.
May I make, Milord, may I make this submission?
Yes.
Since now it is restored, Milord, kindly give us some time. Milord, I do not know what they intend to do, Milord, if they intend to proceed
Yes,
with the Honorable
we'll
Supreme
adjourn
Court.
this matter.
My Lord,
You take instructions.
we will.
What do we do with your application? We can't allow this application now.
Immediately, I understand, because it has been restored
Yes.
now.
Let us dispose this off.
Milord, kindly don't, because that the difficulty would be, Milord, may we come back, kindly adjourn the matter. Let me come back, and Milord, with the application, because this application again revives. So, Milord, this application was filed because the amount still lies with the registry. So, my application is, Milord, in the meantime, when the section 37 is pending, Milord, we would
Sure, ঠিক আছে।
only for this reason, Milord.
চলো let দি তারপরে লেখো ওই তারপরে লেখো let the appeal and the connected applications be listed 3 weeks.
3 weeks. Milord.
3 weeks hence ডেটটা দিয়ে দাও।
I'm very deeply oppressed, Milord.
দুটো disposed of হয়ে গেল 4 and 5.
Deeply oppressed, Milord.
এই 4 and 5 তো লিস্টেই নেই। ট্রিটিং অ্যাজ অন ডেজ লিস্ট করে দিও 4 and 5 টা হ্যাঁ
The restoration application was dismissed entirely on my ground. That I was not available on that
you
particular.
don't have to give grounds, you know this court.
My lord, I'm for the respondent. I'm not standing in the way of the restoration. Only, my lord, I'm
You're standing but not standing in the way.
not standing in the way. Your lordships, I'm being led by Mr. Sinha. If the hearing of the matter could be kindly fixed in the
Milord,
first week
may I
of
do this,
September.
Milord? Milord, formal paper books. It's a very short appeal, Milord, from an order, Milord, adding a party to a winding up proceeding, where only, Milord, the liquidator and, Milord, the court is really involved. Milord, we can, Milord, prepare a short compilation of papers. Your lordship can, this is not going to take more than 15 minutes, in my estimation.
Shall we say informal paper book?
Yes.
Your lordship, a stay petition was filed. We did not get
The state petition has become infructuous because, Milord,
We'll dispose of the
party
stay
has been added.
petition. We'll dispose of the stay petition. It will be only included in the informal paper book.
Yes.
We'll hear out the appeal.
That's right.
My lord.
কবে dismiss হলো?
17th July, Milord, it was dismissed,
আচ্ছা।
filed within time.
This is an application for restoration of APO 80 of 2024,
Order হয়ে গেছে already complied with the.
which was dismissed for default along with the connected application on July 17, 2025. Paragraph, having heard learned counsel for the parties, we are satisfied with the explanation furnished for the absence of learned advocate for the appellant on the day the matter was dismissed for default. Paragraph, accordingly, the order dated July 17, 2025, is recalled. Stop. APO 80 of 2024 is restored to its original file and number along with GA1 of 2024. Paragraph, GA2 is the restoration.
Yes, my lord.
GA2 stands disposed of. এবারে তুমি অ্যাপিলটা GA1 টা নিয়ে ওটার তলে একটা অর্ডার হবে। Mr. Shaha, learned senior counsel appearing for the appellant, fairly says that there is no scope for passing any interim order in this matter. Stop. The appeal has to be heard out. Stop. A very short point is involved. Paragraph, as suggested by Mr. Shaha, let the appellant prepare requisite number of informal paper books, incorporating therein all papers that were available before the learned single judge, as also a copy of the stay petition. Stop. All formalities are dispensed with. Stop. You are for all the respondents.
I'm for only one respondent, Your Lordship.
How many respondents are there?
Respondent number one, Your Lordship. There are other respondents also. Official liquidator is as well there.
Since the respondent number one is represented through learned counsel, notice of appeal is deemed to be waived insofar as that respondent is concerned. Stop. Let notice be issued to the other respondents. Paragraph, the stay application stands disposed of. GA1, GA1. Paragraph, list the matter. For how many? How much time you?
Well, we'll do it in 2 weeks.
With your informal paper books, within 2 weeks add করে দেব। List the matter 2 weeks hence under the E.
Your Lordship, Mr. Sinha will not be available from 12th to 19th September. I'm being instructed if it
No, no,
could
we
be
can.
after that.
ও তাহলে GA1 কিছু
We can do it before that, my lord. It's very short matter.
Yes. Under the appropriate heading within the first 5 items.
Your Lordship, I could not, I beg your pardon, could not hear the date, Your Lordship.
2 weeks, give the date. বলে দিন, ডেটটা বলে দিন।
Grateful.
Grateful, Your Lordship.
My lord, could it be the 3rd September? My lord, there be some difficulty.
10th,
8th, 9th or 10th September?
10th.
Yes, great.
3 weeks hence. তো সব কটাই 3 weeks করে দিন।
Grateful,
পেপার
Your
বইও
Lordship.
3 weeks।
Item number 4 and 5.
Lordship, last time there was some technical in the substitution application that has been removed. We have filed an affidavit of competency and has been reaffirmed.
The substitution. Now is it all right? You are for the appellants.
Lordship.
Who has died? Respondent number 6.
Respondent number 6 in 319. APOT 319. It is respondent number 6.
Issue. This is an application for recording the death of the respondent number 6 and for bringing on record her legal heirs. Stop. Paragraph, we have heard learned counsel for the parties. Stop. We see no reason not to pass the orders as prayed for. Stop. Learned advocate for the year for respondent number?
Respondent number 1.
1, in his usual fairness, does not oppose the application. Paragraph, the application is allowed. Stop. There will be an order in terms of prayers B, C, and D. of the, you have a notice of motion
Lordship,
of the notice of motion, which read as follows. করে prayer গুলো দিয়ে দেবে, সুবিধা হয় তাহলে। ঠিক আছে? তাহলে GS কত 5 stands disposed of.
Since no opposition has been filed, allegation, if any, are deemed to have been denied.
Substitution
It
application.
is just for
করে দেবেন। Since we have not called for affidavits, comma, the allegations made in the petition are deemed not to be admitted by the respondents.
I'm grateful.
the next matter, Your Lordship, is respondent number 3.
It's point number 3.
Next.
Just change it হবে. This is an application for recording the death of the respondent number 3 and bringing on record. 3 is male or female?
He.
She. Her legal age. Otherwise same.
Lordship, I have also got an application for stay, which is before Your Lordship. Will it be Your Lordship? Lordship, I'm only praying, Your Lordship, the stay. Because, Your Lordship, there is a cost imposed upon the appellant.
You first get your petition corrected, substitution, etc.
The substitution needed to be carried out.
Let's substitute.
Get your memo.
I'm grateful.
Great.
Next.
Item number 6. 6, my lord, I beg to appeal, my lord, for one of the respondent. Lord, suit has been dismissed. My lord, application for stay has been filed. My lord, well, may I move my appeal, my lord?
I am for the respondent 1.
This is a partition suit, my lord. Partition suit between now 3 living brothers. It was 5, all octogenarians, regarding a property in North Calcutta, where there was a consent decree passed earlier. And they were recalled at their behest, saying that I didn't understand properly. Now, it has been dismissed on the sole ground that one registered deed of 1974 has not been exhibited. That is an admitted document disclosed by defendant number 3.
You are the plaintiff in the
I'm for
partition.
the plaintiff. And this will.
We'll have to hear the appeal.
Yes, but all I am saying is, the lordship, this 80-year-old man, all his brothers, they're 3.
Want some precedents.
Some precedents, and some way we can bring it to an end. So this is.
Mediation will not work.
Lord, on the very first day I tried, Lord, but the demands of the parties are.
No, you are trying, and the efforts of a trained mediator with experience may be different, without meaning any disrespect to you.
My client is willing. No, my client is willing.
Partition suit should.
My client is willing.
Is your client willing? That we have to.
I'm sure because his son lives abroad and he wants his father's property to be, because he gets his money.
Partition.
My client is willing. No difficulty. But you can keep the matter for hearing. In the meantime, set it for mediation.
Yes.
Exactly.
In the meantime, prepare informal paper books.
Lord, you kindly make that order and some precedents, and in the meantime, Lord, you kindly send that to our
Esho, Ashun.
I appear for the respondent number 2. I appear for the respondent number 2. I am also aggrieved by the decree. I'll either prefer a separate appeal or file a cross objection.
We are all together.
Do whatever you
One
like.
brother has died.
Go for mediation.
Yes,
Very well, my lord.
I have also ready.
You are for 2. You are for.
Lord, I am for 3 branch.
The only one who's objecting to the decree.
All the others are together.
Only
All
one objecting.
respondents, all defendants are represented before us.
All here.
No,
No,
but,
4, 5, no.
4 and 5, I believe.
4 and 5 never appeared. Well, they had appeared.
They have.
4 and 5 had appeared in the before the suit court. 4 and 5 hasn't come, but then I'm.
Have you served?
Yes.
Affidavit service is there. Hand service করেছো? And sir.
Somebody is running towards us.
4 and 5.
4 and 5. He's for 4 and 5. 6 and 7.
Number 6 and 7 key.
Now, the respondents in the appeal, my lord, the respondents in the appeal.
I am for 6 and 7.
Then who is for 4 and 5?
I represent. 3 to 5 I represent. Respondent number 3 to 5.
I represent respondent number 2.
All are here.
I am 6 and 7.
So we are sending for mediation. This appeal is directed against a judgment and decree of a learned judge of this court, judgment and decree dated June 19, 2025, passed by a learned judge of this court, dismissing the appellant's suit being CS number 90 of 2012. Stop. The suit was one for partition of a joint property in the northern fringes of Calcutta. Paragraph. We see an element of settlement in this matter. Hence, with the consent of the parties, we refer this matter to mediation. Stop. The paragraph. The member secretary of the High Court Mediation Committee is directed to do the needful so that the disputes between the parties are placed before a trained mediator. Stop. Adequate notice should be given to the parties or to their learned advocates so that they can attend the mediation proceedings. Paragraph lists the matter 4 weeks hence, when the mediator should file his final report or interim report, as the case may be. Paragraph. In the meantime, let the appellant prepare requisite number of informal paper books, incorporating therein all papers that were available before the learned single judge. Stop. All formalities are dispensed with. Stop. Since all the respondents/defendants are represented through learned counsel, notice of appeal is deemed to be waived. Paragraph lists the matter on 4 weeks per 4 weeks per time.
Any day before the vacation, 1 day.
17th, September 17th. Paragraph. The stay application being GA such and such stands disposed of. Stop. However, a copy of the stay application be included in the informal paper book for the convenience of reference.
Lord, my counterclaim has also been dismissed. So, Lord, I will also take out an appeal in connection in the meantime if required.
So one paper book will do for everybody, I suppose.
All the papers should be before us, that's all.
Some position somewhere, because we know.
Amongst the 17, under the appropriate heading, decree to appeal from decree. Amongst the first 5 items.
I'm grateful. Grateful.
Number 7.
Now, to item number 7, I appear for the appellant, my lord. On the last occasion, my learned friend has said that respondent number 2 had died, my lord. Based on that, we have taken out the application, my lord, GA2, my lord, but that is not appearing in the list, my lord. Lordship had directed both the GA and the APOT to appear together on the last occasion. This affidavit of service and my notice of motion is ready, my lord.
Mr. Tiwari, have they served you?
Yes, my
We
lord.
can treat it as on days list and dispose of.
It's not a defective application, my lord. Can you see the petition as if it's filed in the citizen court? Totally, my lord, against the rules of our side. No amended plaint, amended memo of will, no stay petition, nothing in the next. 2-page petition is filed. It's not contrary to the original rules. I've never come
My lord, your
across
lordship had
such
said only
application.
to bring this
Yes,
legal
to-
age on record.
He has to enclose the memo, stay petition, indicate the correction in the reading, nothing done. 2-page application filed. So not permissible in the original rules.
Why don't you consult Mr. Tiwari, find out how it should be drafted? You better withdraw this because he's technically correct, possibly.
My lord, I have 2 submissions to make, my lord, in this case. Number 1, my lord, Mr. Tiwari has not provided me the addresses of the respondents whose name has to be substituted. He is saying that the mothers and the daughters to be given in the same address of the LLP. That is a registered office of the LLP. He's saying to serve it over there only. Why he's saying so, my lord? What I understand, my lord, there is already we have filed a 138 application also before the Bansal court, my lord. Over there, there's a non-available warrant of arrest against all of these people. They are absconded over there, and that's why what I feel he's not providing me all that details, my lord.
Sir, we are directing this matter to be listed 1 week hence.
My lord.
In the meantime, if there is any defect in your application, we have stopped advising after joining the bench.
My lord.
Do the needful.
My lord.
If necessary, withdraw this, file afresh. We'll allow your prayer, no problem, but it should be a proper application. Learned advocate for the appellant says that the appellant has taken out an application for recording the death of the respondent number 2 and for bringing on record his legal heirs. Stop. Let that application being
GA number 2.
GA2 of 2025 be listed along with the appeal on আছে লিস্টে কোথায় GA2? GA2 is there.
It's there.
It's there.
My apologies, man.
কি বললাম প্রথমে? Taken after recording the death of respondent number 2 and bringing on record his legal heirs. Stop. তারপর কেটে দাও। তারপর পরেরটা কেটে দিন। Next. Mr. Tiwari, learned advocate representing the respondents, says that the application is defective and is not in accordance with the provisions of the original side rules of this court. Paragraph. Let this matter stand adjourned for a week. In the meantime, the appellant will be at liberty to remove any defect that may be there in the application.
It has to be withdrawn. It can't be removed. It has to be withdrawn.
Yes, then you better withdraw today and file. That will save time.
Liberty to withdraw.
No. Effective and not in accordance with the provisions of the original side rules. Stop. Paragraph. On the prayer made by learned advocate for the appellant, leave is granted to withdraw withdraw GA number 2 with liberty to file afresh. GA2 is disposed of.
My lord, I am grateful, man.
Item number 8.
My lord, this is my application arising out of dismissal of an application for grant of probate, uncontested. It's been dismissed basically on 3 grounds. Firstly, he said it's unnatural because it's a bequest to a stranger. Secondly, he says the will was not executed in the presence of relatives, sons and daughters of the tetratrix. Therefore, thirdly, he says there remains a doubt whether this is the last will and testament of the tetratrix. Can he take 63? There's one paragraph, the judges summed it up.
63.
Page 63, running page 63, which is also next to the stay application. দুবার করে অ্যানেক্স করেছে, আমি জানি না কি করে।
যাবে মনে হচ্ছে নাকি? Which is the internal page number?
Internal page number 7 of the impugned order.
Yes.
Registered will. Summons was served, could not be served. It was served by publication, no objection from any of theirs. Registered will.
Whose will? Ramadatta Gupta.
Ramadatta Gupta.
Who are Gopal Das and Abhijit Das?
They are the executors and the
Executors
executors
name,
and beneficiaries.
executors and beneficiaries. Rama did not have any family.
Rama did have family. We attempted to serve them. It came back left. It was served by paper publication in terms of the order passed by the trial court. There was no response, no caveats. Registered. This was a will in respect of a limited property situated in Digha.
Don't you have to, wouldn't issuance of citation be necessary?
Yes. That was done.
That was done.
By post. It came back with the remark left. Therefore, it was served by paper publication.
Who issues citation? Department or? Citation issued by whom? The department or?
The sheriff's mode was there. After on being satisfied with the mode of the sheriff, then the learned judge directed paper publication. It is not as if everything was given away to a stranger. Only a property in Digha was given, and the will makes it clear why she has done so. The order again, page 47. Well, the order at page 47 will make it clear why it was done by paper publication. Because কেন করেছে কি বলেন? But at internal page 7, the second paragraph, it has been summarized.
Mr. Chaudhary, take your seat. Allow us to go through the order once.
ওই ছাত্রের টাকা তুমি তো ছাও
What does attending witness mean, Mr. Chaudhary?
If both the witnesses,
Attesting witnesses are not available,
yes, then somebody else
has to come and prove the handwriting of the.
He was present at the time when the will was executed, though he was not one of the
Oh, I see.
signed.
He attended the occasion of
He attended the
execution.
occasion and saw what happened, but
I
was
see.
not one of the two signatories.
I see. I see.
My lord, in this case, one of the attesting witnesses filed his affidavit, except that it so happened that he died after filing the affidavit.
What about the other attesting witness?
Other acting witness we have not been able to find. But in law, only one was required. One came, one filed his affidavit. It so happened it was supposed to have gone on fiat. The learned judge suddenly said, "No, I'll do it in solemn form."
Even if he had come, there was nobody to cross-examine.
Yes, there was nobody to cross-examine him. His affidavit remains on record. The two judgments were learned judges cited. Those refer to cases where he's been kept away, but he's not been kept away. He came, but he died.
Have you filed a stay petition? No.
I have filed a stay petition.
Have you annexed all documents?
Everything is on, all papers are on record in the state.
Including depositions and all?
Everything. Everything. I formally prayed for liberty to file without a certified copy, which I have not yet got. That's the basic tenor of the stay.
That's all right.
All papers are on record.
We'll list it again. We'll treat this as the informal paper book. We'll dispose of the appeal. We'll go through the records ourselves. After all, the probate court is a court of conscience.
Exactly.
We have to satisfy ourselves. And we'll keep it after 2 weeks. After 2 weeks, huh? We'll dispose of the stay application, Mr. Chaudhary.
Very well. My lord can keep both, then it appears more at the top. If it appears as an application, and
No,
my lord,
that we'll ensure otherwise. But you need a stay application to the. You file an informal paper book. Or is the
all papers are on record.
not
Everything
necessary.
is on record.
Not necessary.
Deposition.
হ্যাঁ, deposition সবই আছে বলছে। There will be an order in terms of prayer A. You have taken out a notice of motion?
Yes, no, yes, ma'am.
Prayer A of the notice of motion. Stop. Paragraph, we intend to hear out the appeal itself. Stop. We are told that All papers that were available before the learned single judge have been annexed to the stay petition, including the depositions of witnesses. Stop. Paragraph, let this matter be listed once again on 2 weeks since মানে তারিখটা বলো no 10th
That 3rd September.
3rd 2 weeks হলে 3rd হচ্ছে August 3 September 3 under the heading short appeal ঠিক আছে উপরের দিকে দিয়ে দেবে আর আমাদের রেকর্ডটা দিয়ে দাও ওনার রেকর্ডটা ওনাকে আমারটা একটা ফাইলে ভরে সব দিয়ে দাও
কি বলেছো? My lord, it's a registered will. If anything further, my lord requires to assuage the conscience of the court, we are willing to do it.
Item number 9.
This is my appeal, my lord. But may I start by saying, my lord, I'll just give a very short background on this. But it's an appeal from an order passed in an originating summons suit. On the first day, without service, my lord, an interim order is passed in the nature of an injunction without any application also for an ad interim prayer.
Who's the plaintiff?
And the plaintiff is my learned friend's client.
Is there a Trivoli court on Baligan Circle Road? Address of the plaintiff respondent is shown as Trivoli Court. Cause title. Address of the plaintiff. See, yes.
That's for them to residing at Trivoli Court. Yes, my lord.
Is it Trivoli Court? This is what I'm asking. R is there.
Trivoli.
It's Trivoli Court. Right?
Trivoli, yes. Trivoli, I think.
Trivoli, it's Trivoli Court. I cross that every day.
I was more worried because I was thinking on other terms that your lordship would say that.
Oh no.
That's why I got very. देखा ना वो originating summons suit की लिखी जो देखा ना.
Which Vadwas are these? These Vadwas are these the Champdani Vadwas?
Yes.
Champdani Industries released. We are not inclined to take up this matter on the personal ground of one of us. Aman Namta Devin, paragraph. This matter stands released from our list. Stop. Let the matter be placed before the Honorable the Chief Justice for appropriate direction.
Immediately, because
immediately we'll sign our this.
Very grateful. My apprehension came true.
I was the standing counsel for Chapdani and the entire group.
I'm sorry, I was not aware. But I thought the Tivoli, I've overcome the Tivoli now. This was too much.
And Jayashri Vadva rang a bell also. Therefore,
it did, my lord, I know.
Good.
জানি সবকিছু তোমাদের ব্যাপারে গ্রেটফুল মানে
তোর ব্যাপার হয়ে যাবে
আমার ব্যাপারে কি জানো
মধুয়া জানে পূজারা জানে
2010 তারিখ
New application, item number 10.
नहीं
appear for the review applicant, my lord. I'm led by Mr. Chaudhary, my lord. He's engaged in other court, my lord. Till such time, my lord, I'll try to
No,
hold
no
the-
question of till such time. You begin and then end, or you don't begin.
Well, I think I have an opportunity to that. I should utilize it then.
Yes, you argue. Yes.
I have a note from my advocate record also. So, Lordship, my lord, this is an application for review of your lordship's order, my lord, dated 23rd of July 2025. So the order starts at page 18, but the operative portion, my lord, which we'll be relying on, my lord, starts at page 30. Because till paragraph 29, 30 rather, my lord, lordships have discussed, my lord, the merits of the case, my lord. Then starting paragraph 31, my lord, it has been discussed as to, my lord, whether the court which had passed the order, my lord, had the jurisdiction or not, my lord. So, my lord, the root question of jurisdiction has been discussed, my lord, paragraph 31 onwards. Thus, may I place, my lord, paragraph 31 onwards. It's at page 30, my lord. Since the challenge has been thrown to the jurisdiction of the court that passed the order impugned in the present appeal, the same needs to be decided first. It had been contended by the appellant that the order should have been passed by a commercial court and not a court exercising ordinary original civil jurisdiction, inasmuch as the dispute between the parties is a commercial dispute. Next, Mr. Chaudhary, appearing for the respondent, had submitted that the same court which was exercising ordinary original civil jurisdiction was also exercising the jurisdiction under the commercial division on the relevant date when the matter was heard and decided, and as such, the order impugned, even if expressed to have been passed by the court in exercise of its ordinary original civil jurisdiction, could not be said to have been passed without jurisdiction. My lord, this, my lord, perhaps, my lord, is factually incorrect, my lord. The judge did not have jurisdiction of commercial division then, my lord. Now, since there was no opposition to the aforesaid submission made by Mr. Chaudhary, we proceeded to hear the matter on merits as well. Therefore, my lord, this issue, my lord, was not gone into, my lord, that deep because of this submission made by Mr. Chaudhary. My lord, the other side also, my lord, did not press much so far as, my lord, the jurisdiction is concerned, my lord. Therefore, my lord, the matter was proceeded with on merits. Next.
Oh, সেখান থেকে yes, Chaudhary.
Deep.
The review is on a very limited ground.
What do you have to show us that on the relevant dates, the learned single judge had both the jurisdictions or determinations, whatever it is?
My lord knows, my lord, after the commercial division was set up, the initial monetary limit was 1 crore and above. 2015, the Commercial Court Act comes, monetary limit is 1 crore and above. 2018, an amending act comes, whereby, my lord, it was reduced
3 lakhs.
Well, 3 lakhs comes later. I'll come to that. Well, kindly come to page 40. Lordship will get the. It's better to, well, refer to the notification. I'm referring to the. This notification is dated 15 November 2018. Lordship will note, after consultation with the High Court, the pecuniary jurisdiction in respect of value of commercial dispute of the clause 2, commercial division of High Court Calcutta to be not less than rupees 1 crore for the purpose of exercising the jurisdiction and powers conferred on those commercial court under the Act. 1 crore. My lord, as on date when the section 34 was filed, because my lord, lordship knows, my lord, that the applicable law, because jurisdiction is a substantive statute, not a procedural statute. The applicable law as on the date of filing of the proceeding or the suit, my lord, is what is considered. As on date of filing, and this is an admitted fact, because my lord, just this point was taken because there was a change in advocate. My lord, everybody was, my lord, we were ad idem that, my lord, the learned judge has jurisdiction. Otherwise, we wouldn't have proceeded. My lord, it's my fault somewhere, my lord, I couldn't convey. I had said it, but since they have pursued it, my lord, diligently, and I have been run over by a bullock cart, so as to say, because this point, my lord, and this needs consideration, because if this is true, my lord, it will create, my lord, this needs to be settled by your lordship otherwise also, irrespective of whatever view my lord takes. So, my lord, 2018, it's still 1 crore. Lordships can take it from me when it is instituted. It is a non-commercial dispute in the sense of pecuniary limit. Otherwise, my lord, it's a agreement, works contract, it may be a commercial for the purpose, because, my lord, for commercial dispute to be tried in the commercial division, there are 2 parameters. It has to satisfy commercial dispute definition and
Specified value.
And it has to satisfy the specified value. So specified value, and my learned friends are also not in a position to dispute that, specified value would not have, when I filed the section 34, it wouldn't have come, because, my lord, commercial specified value was above 1 crore.
What was the amount involved?
Here was, my lord, 35 lakhs or 31 lakh 3,909.
What was the claim made? Amount of claim made?
Well, claim made is also less than 1.
Less than 1.
34 lakhs and not. 31 lakhs was granted. And this is, my lord, unilaterally, because we had taken, my lord, the point was the jurisdiction and all that. Merits I am not, my lord, this is a limited on the review only. So, my lord, as when AP was filed, that is, my lord, AP 831 of 2018 was filed. It was, and at that point of time, my lord, what is important to note is the commercial division was existing. There is no question of application of section 15 or transfer. It's a fresh filing. When it was filed, my lord, it's existing. So, and correctly, because otherwise, my lord, the department itself would have not allowed it. And correctly, my lord, it was filed in the non-commercial and regular, my lord, ordinary original, my lord, the arbitration.
When was it filed?
6th of December.
6th of December. 6th of December 2018, filing date. 6th of December 2018.
After this notification.
And then, my lord, kindly come to page 41. This is a notification of 20th March 2020. And, my lord, on 20th March, 2 notifications were issued. One is at page 41, but we are really concerned with page 42. Kindly come to page 42. B. In case of commercial courts within the territorial jurisdiction of City Civil Court at Calcutta of an amount not less than 3 lakh and not more than rupees 10 lakh exclusively, and exceeding rupees 10 lakh but not exceeding rupee 1 crore concurrently with commercial division of High Court at Calcutta. And C, in case of commercial division of High Court Calcutta on an amount exceeding rupees 10 lakhs. So 2020, when, my lord, 2 years later, this happens when the jurisdiction is changed. So now the question is whether at all it can fall under, or it should be under the, there is no question at the time of filing. It doesn't. It was not a commercial, commercial dispute to be heard by the commercial division. In fact, better expression will be, it is not supposed to be heard by the commercial division because of the pecuniary or specified value.
Yes, it may have been a commercial dispute, but not to be heard by
not to be heard. And, my lord, it was correctly, my lord, it was correctly instituted as on that date. And then, my lord, one important aspect. At page 37, Lordship will find this is the first time, my lord, it was marked part-heard by the learned judge. And when it was marked part-heard, then also, that is in 2019, page 37. Because, my lord, this was, my lord, when COVID was just setting, but it's in 2019, it had not taken a serious turn. Then, my lord, March 2020, we all know what happened. But it was marked part-heard, it was argued. And, my lord, kindly see, they had also appealed earlier, page 38, not in the commercial division. It was admitted there also. Now, my lord, the only question is, and my lord, my learned friend did not pursue it casually, he had mentioned it. He had said that section 15 there is a transfer provision. So it ought to be have been transferred. This was all he had said. Assuming that it has jurisdiction, it ought to have been transferred. But when I'll come to this point later, since, my lord, I have filed I had to file a review. My lord, lordships have proceeded on the basis as if, my lord, it is a commercial, it was to be heard by the commercial division, and as on that date, my lord, the learned judge did not have the determination. But, my lord, in view of these facts, my lord, these should have been, because, my lord, I must be candid, this notification was not available, this page 42. This is the first time I am showing your lordship. We did not get hands, my lord. This was very difficult to get hold of. But because, my lord, we somehow, my lord, from the government offices, it's not readily available in the internet for some reason or other. But, my lord, that is why, my lord, I had only submitted. My lord's officer will know, my lord, when the date was that, because it was recorded in another order of, I believe, my lord, Justice Mojumdar, Justice Sugato Mojumdar. But that is it. But, my lord, the admitted point now is that it was filed in the non-commercial division correctly in 2018. The commercial division, my lord, did not and could not have any jurisdiction. And this is all happening after the constitution of a commercial division. So it is not a case that after the constitution of commercial division, a case is pending and because of the constitution, the case is required to be transferred. No. Section 15, my lord, with respect, and I'll show that also. Section 15 transfer is, my lord, that commercial division once constituted, what will otherwise qualify, my lord, will be transferred. Now, my lord, lordship will also have a look at our practice direction limit.
So essentially what you are saying is that when it was filed in December 2018, it could only be filed in non-commercial division.
Correct.
So after filing, the subsequent notification of March 2020 would not make any difference.
Would not make
The transfer contemplated under section 15 is not that after filing, if pecuniary limit is reduced.
Correct. And, my lord, in this, apropos this, my lord, kindly also have a look at our practice directions, which was notified. My lord, this clarifies. This direction came much later, but this clarifies the position. Lordship will have a look at. My lord, direction, my lord, 4.2. 4.1 and 4.2, Lordship will have a look. And, my lord, on that date, I also, my lord, asked my juniors to get hold of the cause list. My lord, the cause list, my lord, there were several matters of, my lord, of the learned judge, which was part-heard, my lord, it had appeared. दिल्ली judgment আছে।
Yes.
My lord, before I come to the practice direction, my lord, if now my lord just reads my lord's order from paragraph 31 onwards, my lord, lordship. Lord, I must be candid, my lord.
In paragraph 13 of your, whatever this is, review petition,
Yes, my lord.
it is averred
Ah.
that some notification was handed up to the court. We can't remember.
No, 15 November was handed over, but my lord, 2020 was not handed over. Huh?
Records है देखो तो? No.
I stand corrected, my lord. The reverts may have happened. It's a mistake. Sorry, the reverts had happened. One notification was not there. My lord, I recall, my lord, I had submitted that, my lord will get that. It's an admitted position. When we had filed the petition, it was not there. Correct. I stand corrected. My lord, I don't join issue, my lord. It's a question. Because, my lord, I found that notification, my lord, because after my lord's order and we were unable to, I said, I am not going to file a review until you show me in black and white in the notification. We got hold of that. To that extent, my lord, it's a reverse, my lord. It is, I tender apology. Well, it is not, I am not saying, my lord, the court made a mistake, my lord. Kindly do not take me amiss. I am not saying that. My lord, it is that, my lord, I was under the impression my learned friend took it as a point, but he would not be serious enough. But he was serious enough, and rightly so, he is entitled to take all points under the sun, and he has successfully taken it. Now I have, my lord, it is my chance in review, my lord, to undo, my lord, what he has done. So, my lord, now, my lord, only question is whether, and my lord, I hear whispers now, and he has said transfer. He is saying it ought to have been transferred. So, my lord, transfer is, section 15 doesn't apply at all, because my lordship will now take section 15. In fact, my lord, I handed over the practice directions. My lord, this position has also been recognized in our practice direction. Kindly take, my lord, rule 4 and 4.1 and 4.2. The practice directions were, of course, notified in 2023. I am not at all suggesting that it was applicable then, but all I am saying is it clarifies the position in law. Every suit, appeal, or other proceeding pending before city civil court as per Bengal, Bihar, Assam civil so-and-so, or in the High Court immediately before the issuance of appropriate notification of the pecuniary value in terms of section 3(1)(a) of the Act. The Act here is the Commercial Court Act, because we are concerned with the Commercial Court practice direction. Being a suit, appeal, or other proceeding, the cause of action whereof is based, and the valuation of the relief of which is such that it would have been if it had been filed after the commencement of the Act within the jurisdiction of the Commercial Division or Commercial Appellate Division in the High Court, or within the jurisdiction of commercial courts or commercial appellate court at district level, shall be transferred by the registry to the Commercial Division or the Commercial Appellate and so to the commercial courts, as the case may be. So, after establishment shall be transferred. Now kindly come to 4.2. The above provision of transfer shall not be applicable to suits, appeals, or other proceedings instituted before any civil court as per Bengal, Agra, and Assam Civil Courts Act, or in the High Court in its ordinary original civil jurisdiction after the date of issuance of the appropriate notification of the pecuniary value in terms of 3(1)(a) of the Act. So, my lord, otherwise, my lord, it will create chaos. Notification changes and, my lord, matters going on lock, stock, barrel. No. And, my lord, to this effect, my lord, lordship will also consider Delhi High Court judgment. But here, my lord, the Delhi High Court division bench was
Yes.
Well, here, my lord, section 19 of the amending act was also considered. I'll show your lordship para 27. But before I show that, my lord, kindly come once to 19 টা কোট করা আছে এখানে নইলে একটা বার কর amending একটা দেব well kindly come to para 27. I'll come back. Para 27. It cannot be said that there is any lack of clarity or ambiguity in the phrasing of section 19 of the amending act, which categorically states that the provisions of the amending act will apply to cases relating to commercial disputes filed on or after the date of commencement of the act, that is 3rd May 2018. So, my lord, even after 3rd May 2018, when we had filed it, even in the then amending act, my lord, so far since no notification was there, we were not getting covered. Furthermore, interpreting the amending act to be retrospective in nature will affect the substantive right of parties who have already filed their suits in ordinary civil courts before the amending act was enforced. Holding it otherwise will and also lead to administrative and practical difficulties, which cannot be said to be the intention of the legislature while promulgating the said amending act. Had the legislature intended for the amending act to be retrospective in nature, there is nothing that could have prevented the legislature from explicitly specifying the same. Well, at section 19, lordship will find this is the amending act of 2018, pursuant whereto section 3 of the Commercial Courts Act was amended, and section 19 is quoted in paragraph 20. My learned junior rightly points out. The amending act also says, save as otherwise provided, the provision of this act shall apply only to cases, commercial disputes filed on or after the commencement of the act. So even when, my lord, the amending act comes and, my lord, it says that it can be reduced to that, my lord, it says it will apply, it will have a prospective operation. And even after the amending act, when I actually file it in December 2018, on December 2018, even after the amending act, when I am filing it, it is not under the commercial division. It doesn't come.
You have this amending act with you?
Yes. I have got hold of it. But I am sorry, my lord, it is lack of anticipation on my part. I should have taken the point more seriously and have brought all these facts to before your lordship's notice. But, my lord, I did not think, my lord, that this point, I thought they had taken it. I did not think that this would be. Because really, my lord, it cannot have any basis, my lord. Just taking it out of the act, my lord, it cannot have any basis. And, my lord, lordship will find section 3 of the act was amended by section 6 of the amending act. Section 6 of the amending act, my lord, kindly see, in section 3 of the principal act, (3)(a), I am not, we are not concerned, my lord, kindly, yes, 3A, my lord, second proviso, provided further that with respect to a territory over which the High Court have ordinary original civil jurisdiction, the state government may, by notification, specify such pecuniary value which shall not be less than 3 lakh rupees and not more than the pecuniary jurisdiction exercisable by the district court as it may consider necessary. So even the amending act is saying that proceedings prior to this and in this and my lord, the notification pursuant to this, I showed your lordship, my lord, in 2018 it was 1 crore and 2020 it was. So even the amending act, my lord, it doesn't, my lord, and it makes it, my lord, categoric that from 15 to 18, whatever has happened, this will not affect that. The intention of the legislature is clear. The reason why I rely on the amending act is to show the intention of the legislature. That what would happen that after the 2018 amending act, proceedings in between 15 and 18, similar contention will be raised. Once it should be transferred. So, my lord, the legislature was conscious of this and it took care of the situation, and that is why section 19 of the amending act was introduced, which lordships have noted. Save as otherwise provided, the provisions of this act shall apply only to cases of relating to commercial disputes filed on or after the commencement of this act. So, my lord, the date for consideration is the date of filing. Even the amending act says so. So once it is the date of filing, and on the date of filing, my lord, I invoke the jurisdiction of the non-commercial division or the regular jurisdiction of ordinary original civil jurisdiction of this court, my lord, rightly. And it proceeds, my lord, from 2018 till 2020 and thereafter. So there is no question of of which judgment?
Anything else?
My lord, only just once, my lord, the Delhi High Court judgment, I forgot to show your lordship para 26. I read para 27. I just read one more paragraph, my lord, and I finish. Because this is really, my lord, also, my lord, this is what was considered by the Delhi High Court division. In the instant case, the petitioners have stated that as per the lowered specified value of rupees 3 lakhs by way of the amending act, they are entitled to the transfer of the suits to the district court commercial in wake of section 15 of the parent act, which stipulates the transfer of pending suits to the designated commercial courts. It is further stated by the petitioner that this interpretation of section 19 of the amending act would further the purpose for which the Commercial Courts Act was brought in. In the considered opinion of this court, this argument of the learned counsel for the petitioners does not hold any weight. And then, my lord, the reason has been given. And I am deeply obliged. Well, I am not reading again para 33 onwards of lordship's order. In light of this, if my lords read, my lord, it's lordship.
Lord, we had argued it, my lord. Lordships had taken a view. My lord, what my learned friend is arguing today, subject to correction, my lord. Non-consideration of a vital document, my lord, though it's mentioned in paragraph 13, whatever the document it is, my lord. Now, my lordship has taken a view. Now, my lord, what lordship, it's a subject to correction. Lordship will correct me, my lord, if I'm wrong. It may be an erroneous decision. Non-consideration of a material part of a statute. Whether, my lord, it's a ground for review or not. Is it a ground for review? We are not rehearing the appeal. We are not rehearing. I'm sorry, I'm very sorry. We are not rehearing the appeal. We are, my lord, hearing a review. Whether, my lord, the points taken by my learned friend squarely comes, my lord, within the point of review. If it comes, lordship will exercise a jurisdiction.
No, Mr. Ghosh, point is this. As we have recorded in our judgment,
Yes.
There was no opposition to the contention of Mr. Chaudhary that on the relevant dates, the learned single judge had both the determinations. Now, that was a different way of putting a thing. Therefore, we proceeded, but then on our own, we found out what that she may not have had commercial jurisdiction. Point is, our attention was not drawn, or we did not consider a binding law So we can always review our own order if we think this is a court of record after all,
Yes,
that we have committed an error.
correct.
Therefore, you see, nothing really turns on it.
Matter has to be reheard once again.
Reheard.
Yes, naturally, review, you are recalling an order. So it has to be reheard, posted for rehearing again.
Para 1 to 30 is all on merits, my lord. If
Well,
lordships
maybe.
are with me, my lord, on
Lordship has
merits,
not
I have
given a
not made
finding.
any submission.
It has to be reheard again. Otherwise, I will go for the review. It has to be reheard again.
It has
cannot
to be reheard in the sense, Mr. Chaudhary,
Yes, it has to
we
be
had
reheard
disposed
again.
of only on this
Well,
point of,
It has to be
it will
reheard
have to be,
again.
now it will have to be heard on merits.
Merits. Will not question, will not whether lordship will go into the merits or not.
If there is a mistake in not considering a law which is binding, then that is a good ground for it.
Yes, that's a good ground. Now, I'll show
Binding
the
precedent,
notification. The
non-consideration of
notification.
No, not only the notification. The best point is the amending act. If you see the last paragraph, I mean section 19, which was placed by Mr. Chaudhary,
Correct, Miller.
which says that the date of filing is something which is relevant, then that answers the point. Filed on or after the date of commencement.
But I have an answer to that. Lordship can hear me today. Lordship can keep it on some other day, any day. I'll come better prepared.
Yes, we'll hear you today.
Yes. Lordship will
We'll
keep
finish
it
it
on some
off.
other day. I'll come better prepared because I have to then address Millard on the merits also.
No,
Because
merits,
rehearing has
merits
to
we
be
will not hear you today.
keeps it on Millard, keeps it on Monday, Millard, I'll come and argue.
We are, as of now, we are minded to review our order and recall the order.
Yes.
And hear it on merits. If you want to make submission opposing that also, we'll have to hear you, not on merits. Why we should not
Keeps
recall
it on
this
Monday,
order.
Millard, because I think, Millard, this is not a ground of review. I'm carrying the judgments. I want to
The
be
law,
ruled for
the law should be, if we have laid down incorrect law should be corrected.
Correct.
I
Lordship
mean,
will
our,
hear me on that on Monday. Where is the difficulty? Lordship has heard.
we'll forget again.
No, may not. Lordship will not forget. Lordship remembers. Lordship pulled it out. Lordship hears me on Monday. What is the difficulty?
Difficulty, what is the difficulty in hearing you next year?
No, I'm not similar. Kindly, Millard, come, Millard. He has cited all these notification. I also have to check. These are not part of the records. If it's not part of the record, how do I respond?
Lekho. Mr. Shobhushaji Chaudhary, Kamalarit Senior Counsel, concludes his opening submission in this application for review of our judgment and order dated December 3rd,
23rd July
23rd
2025.
July 2023.
July 23, 2025, whereby we had allowed the appeal of, whose appeal was it?
It was my appeal.
Appeal of
Garden Ridge Shipbuilders Engineering.
Garden Reach Shipbuilders and Engineers Limited, being APO number 84 of 2023, solely on the ground of jurisdiction. Paragraph. On the request of Mr. Devnath Ghosh, learned Senior Counsel representing Garden Reach, let this matter be listed again on Monday, you said?
Monday. I'll take instruction also if Lordship is willing to hear the matter on merits.
On merits, yes.
Because
so don't trouble yourself too much.
Yes, I'll take that because kindly look, it's a government. I have
No, you take instruction. Satisfy yourself as a lawyer.
Yes, I have to. That's the reason, I took time, Otherwise, I took time. Otherwise, his lordship is reposting the matter for final hearing on merits,
Under
no
the
one
same
is agreed. Neither am I agreed nor
at the same position.
Because lordship has not decided any merits, and in the meantime, everything has washed off. So now it has to be reheard on merits. Second right at the 10. তুমি তো second right শুরু করবে।
You.
The benefit of your learned friends, we are asking roughly how much time you'll take, Mr. Ghosh?
Today, I shall take
Rest of this half? Rest of this half?
oh yes,
Easily?
yes,
Oh, we have a matter fixed at
12:30.
12:30. I see.
yes,
Then accepting the 12:30 matter, all others can be released for this
yes.
till recess.
Even after recess, my lord, you give me 1 hour's time, then you can lordship it here.
শোনা যাবে? Yes, yes.
Up to 3, your lordship gives me, then your lordship can hear others. See, because today what I propose to do, my lord, in this period, this very short period, just to sum up what I said on the last occasion, why majority award.
তো শরীরও তো আজকে অ্যাপেলের ছেড়ে কোনো চান্স নেই। প্লিজ যেটা যে কোন সাইড Yes.
First, why the majority award should not be upheld. And then I shall go through the minority award and show that minority award has taken care of every point. Most important point below today I shall urge before your lordship is that which goes to the very root of the matter, the chart, which even the appellant did not argue, even before your lordships. The chart was the most vital document handed up by VSPL. So this is the quantum we had handled. Then we were invited to hand up a chart. We were ad item, in fact, they showed more. And I showed you lordship, per year we gave them 1 point on an average. Sometimes we went beyond 2 million also, 1.95. That's why, my lord, when I placed clause 5.12, I said expected. Kindly make a note of this word expected. That will have some bearing when I my argument. Expected to go beyond 2 million tons. So when I gave one year went beyond 2 million, 1 year was 1.94, 1 year is 1.86. There's no whisper in the majority award. This is a classic case of not adverting to a very important relevant document and non-application of mind. Both hit by Associated Builders versus DDA against the public policy. I don't have to go any further even in this matter. It's clearly laid down by Justice Nariman. Both these are non-application of mind and not considered relevant document is against public policy. Now, my lord, just to tell your lordship, this was the first point I want to advert to your lordship. This has got to be set aside in any case. That's my humble submission to your lordship. And I showed the chart is what I showed you, lordship. Kindly, at the risk of repetition, may I show you lordship? Volume 1, page 119. I'll prefer me to kindly come to page 121. Shown side by side, sales quantity and VSPL quantity were ad item. There's no dispute. So, if this this whole thing goes to the very basic, it goes to the root of the matter. Why I say this? Once my lords accept it, then it's the second part of clause 5.12 that applies. Not the first part. Kindly take clause 5.12 once. What does it say?
It's 81.
That's at volume 1, page 81. Okay, thank you. Not that the majority was unaware of it. Kindly take the majority award is at page 18 also. They've set out this clause. VSPL shall ensure storing of cargo grade-wise up to a maximum. My lords have got it? Yes. To ensure storing of the cargo grade-wise up to a maximum of 4 grades and up to a minimum cargo volume of 60,000 metric tons. We have to give them, otherwise we'll be penalized.
Maximum cargo volume.
Maximum cargo volume of 60,000 metric tons. If we give them below this, there's penalty clauses there. Nobody is disputing that. In case of exigencies, to accommodate a cargo of further 30,000 for a period not exceeding 15 continuous days. Kindly make a note of the word continuous. So 90,000 becomes. However, SAIL shall give 30 days notice to VSPL to organize stacking requirement of such higher cargo volumes. If the cargo commitment by SAIL to VSPL is expected to go beyond, not it must go, expected to go beyond 2 million metric tons, VSPL shall organize storage of cargo up to 90,000 metric tons with a further provision of 30,000 metric tons in case of exigencies for a period not exceeding 15 days. So this is the second part which will apply, not the first part. We have given them cargo every time it was more than nearly up to 2 million metric tons or beyond. We have given. So it will be 120,000 metric tons. They should be able to store it at any point of time if it is expected to go. We gave them the number of vessels coming every year because we chartered these vessels, Panamax vessel, big container vessels coming. Sometimes the charter may fail, sometimes the cargo may be a little bit of difference. So they were fully aware. But there was never 120,000 metric tons kept for 15 days at all. And no question of giving any notice to them. The majority throughout proceeded on the basis, including the parent, that first part applies. It is astonishing. So it is error apparent on the face of the award. Throughout, I'll show your lordship, and I had shown your lordship. Now, kindly come to their para 52 of the award. Para 52 টা award কোথায় আছে?
Page.
Award
and the award is para 52.
We will give you a lordship one volume only of the award. That will be very helpful. As I have got it, only the award.
কোথায় আছে অ্যাওয়ার্ড দেখো
What is it? 478.
478,
478.
the petition, my lord, and
No, stay petition.
my lord, I'm just
What is 52?
Huh?
What is 52? Say,
No,
paragraph,
please,
paragraph,
paragraph
52. 493. Page 493.
Volume 4, page 490,
78.
493. The award is written when the award is written when the chart was with the tribunal. Kindly take clause page
52.
paragraph 52,
At page 493.
page 493. On plain reading of clause 5.12 of the STA, as quoted by us above, it shall be the same consists of two parts, two distinct parts, which is also admitted by all. And in two parts, the provision of free period of 15 days has been separately mentioned. And in case of the first part, it specifically mentioned the provision of 30 days notice. And then next paragraph. The first part of 5.12 again consists of three sentences. The first sentence will show up to a maximum cargo volume of 60,000 metric tons. The second sentence, accommodation of 30,000 and for a period of 15 continuous days. They failed to prove this also. That I shall be coming to now. Kindly come to 55, 56, 57 of the award, majority award. It is a pointer to note that for the second part of clause 5.12, there is no whisper of notice, although there is period of 15 days. Because the first part is for day-to-day clearance of cargo, beginning the cardinal principle of MPT. This again, it is a private contract. They're bringing in MPT every time. Major Port Trust Act and TAMP. They're operational. They are, on one hand, they're saying it's a private contract. We can determine the terms. Next, 56. The second part of the clause deals with cargo volume on per year cargo commitment on the basis of VSPL should keep ready to accommodate 90,000 plus 30,000 in exigencies for a period of 15 days. And this is when the cargo commitment by sale to VSPL is expected to go beyond 2 million metric tons. So they were conscious, the chart was in their hands, and still, kindly say, in the instant case, para 57, VSPL claimed demurrage stroke storage charge on the basis of the first part of 5.12 of SDA. In view of all above, our mind leans to accept the interpretation of the clause that when the volume of cargo exceeds 60,000 metric tons, continues to 15 days without any 30 days notice from sale, VSPL is entitled to demurrage stroke storage. It's totally errored on the basis of facts and figures. And the appellant did not dispute. But when I come to the minority award, they have dealt with in detail regarding this chart. And throughout, thereafter, my lord, I will not trouble your lordship, your lordship has gone through it enough, that they have dealt with only the first part. So there's error apparent on the face of the award when the second part applies. So this is my first point. My second point was, my lord, also I must say, the president also during the course of his argument conceded that the word demurrage does not appear in the agreement at all. Mr. Ghoshal conceded that point. The word demurrage does not appear. They have rewritten the award. They've rewritten the award, the agreement, which the tribunal cannot do. Major Port Trust Act and so far TAMP is concerned, sale has got nothing to do with it. The VSPL has taken on license a certain area in VPT, and they're paying the license fee, and they're bound, whatever the terms and conditions. So far sale is concerned, there is ITSC. This is the integrated terminal service charges, covering all. And even in the ITSC, there is no question, they have not mentioned the word demurrage. All the argument that regarding Major Port Trust Act and TAMP really should not apply, because it does not automatically come in a private contract. They are entitled, and they've also contended with tribunal is a BOT contract. Operational part is ours. We are operating the EQ8 and EQ9. But so far they are concerned, they have got a privity with VPT and TAMP. Then, my lord, then I come to the question of, my lord, the question of, in this regard, question of bias. Kindly come to paragraph 113.
Page 516.
At page 516. The claim commences from 4/5/2009 and ends with 31st March 2012. The period reckoning 4 years. The claim scrutiny of the statement shows it has been prepared on the basis of 3.6.2 of TAMP order. The quantities for each day have been arrived at as per Exhibit C68 daily report. Then they have said this. The statement, my lord, we go on, kindly take the last 4 or 5 lines. The statement, however, does not show the stock reclaimed from the stockpile and loaded in the rakes daily. It is a continuous process. Want of sufficient rakes appears to have caused the accumulation. the respondent, this is below, they have not proved it. The respondent has not disputed the methodology of calculation or the quantification of storage charges. Well, I just said the second part applies, not the first part. Then, the entitlement of the claimant alone has been assailed on different grounds by the respondent. It further appears from the chart the claimant levied storage charges instead of demurrage charges. According to TAM, understood storage charge is lesser than the demurrage, Exhibit C69. Whether it's case of damages for breach of contract or demurrage for exceeding the period of storage or storage charge, for the same reason, it is in sequel to the infraction of clause 5.12. The claim of damages depends upon proof of loss suffered and the quantification thereof commensurate with the loss suffered on account of breach, unlike the latter two categories. It admits of no further proof of damage having regard to the fact situation obtaining in the instant case. It indubitably emerges from the matrix. The respondent allowed excess stock of cargo remain beyond the free period. The consequential loss is obviously the demurrage or storage charges which the claimant is entitled in terms of stamped notification. It's a question of not Mike allowing the cargo to remain. From hook point up to the stockyard, they bring it. We don't touch the cargo. From stockyard to the rakes for onward dispatch, they do it. The sale didn't touch the cargo at all. Be that as it may, this is a question I can't. The rates fixed by TAM towards demurrage or storage charges, as the case may be conveniently adopted in quantifying the damage. The claimant is not entitled to pay more or less for the storage charges fixed by TAM and accept the concession rate given, if any. The contention of the claim of the claimant should go for proof of damage on account of breach. The above reason merits no consideration. In view of the matter of entitlement of the claim for demurrages or storage charges cannot be doubted having regard to the discussion made above. Now, this is important, my lord.
Mr. Ghosh, can we take this up after recess?
Yes, please.
From this
Yes,
para 115.
Para 115.
After recess, my lord, I have some difficulty, my lord.
I'm
Can it be taken up tomorrow instead, my lord? আপনি বলবেন?
Mr. Ghosh may conclude.
Yes,
I may just make some progress, my lord.
Yes, yes.
Fair enough.
Just some. I'm just recapitulating because he was not there. I know. So
No,
just what
I have been kind enough. Mr. Dotto has provided the notes, whatever Mr. Ghosh has submitted to on the last occasion
I
for
told
us to
Mr.
consider.
I told Mr. I shall just recapitulate for your. না না আমার ওই 2-3 লাগবে
আমরা ঘুরে আসবো যতটা থাকিস থাকবে
আমি তুমি যদি তোমার অসুবিধা আপনি তো বলে দেবো আমি জাস্ট লাস্ট বলেছি
আমি বুঝতে পেরেছি স্যার আমি আর্যক আমাকে আপনি যেটা বলেছেন সেটা ওই একটা প্রিন্ট করে আমাকে পাঠিয়ে দিয়েছিল প্লাস আমার জুনিয়ররাও নোট নিয়েছিল তো আই হ্যাভ বিন এবল টু ফিগার আউট
তোমার যখন অসুবিধা আমি বলে দিও
না না প্লিজ কন্টিনিউ obliged
Decide 1236 matter. PD1.
Totorup means one who has 100 groups. Who is that? Krishna? No.
Yes, sir.
My lord, I am being led by Mr. Joysha, who will join us virtually for today.
Why? But if he's arguing, no. Very inconvenient for us.
Okay.
May I start? Well, first of all, my lord, we are now looking at a law which is promulgated. What I could see from the notes filed by the amicus, which I have to deal with, is something which they thought to be the law or should have been the law. So, my lord, today my lords are looking at a law which is promulgated. Now, lordship has to adjudicate within the four corners of that, unless that law is being changed or declared to be ultra vires. So, my lord, what I find from the notes, if your lordship sees, is what the law commission thought of. Now, what they might have thought of has not seen the light of the day. Because, my lord, I have seen the discussion, I'll show it also, that, my lord, the whole argument is on the premise that, my lord, it is still a judgment, would become a decree or a deemed decree, and therefore the appeal is maintainable. Now, my lord, with all humility, this is perhaps not the law. The law, when it was settled and promulgated, my lord, by the legislature, it says if it is a decree, the jurisdiction of this honorable court to entertain an appeal is not there. My lord, this distinction, my lord, is a very thin line, but this is exactly what lordship has to adjudicate. And lordship has, I'll show that on my later stages. My lord has, so I'll show that. But my lord, the fact is that this is where my lord, lordship has to consider that it is no longer said to be what the law commission has said. Today, section 13 has taken its course. And my lord, we have to read section 13 as it is under the Commercial Courts Act. Because, my lord, I'll show why the legislature, even after considering the, my lord, references made and the, my lord, discussions made by the law commission, has ultimately promulgated the law in the manner it is in under section 13 today. Why I say this, my lord? Because they have considered something which perhaps the law commission did not look into or wanted to be, let us put it in more liberal, my lord. But, my lord, that liberal idea no longer exists in section 13 anymore. And I'll show, my lord, the judgments relied upon by Mr. Shah also. My lord, is per incurium, because, my lord, they have not even discussed these issues at all. There are judgments of my lord, my lord Justice Banerjee, and my lord, the other Supreme Courts and High Courts, which have dealt with it. And it has now, apropos the legislature and the judge-made law has become the law of the land, including the last judgment of Bihar, my lord. Now, my lord, apropos this, kindly considers this matter, my lord. Before I, my lord, take into the facts, my lord, which I have to argue once and for all, my lord, so that lordship can pass an order. Now, my lord, kindly considers, my lord, there is no doubt that, my lord, the learned trial court has dismissed the suit on the basis of an Order 7, Rule 11. There is no doubt that they also say, the amicus also say, and therefore they say that it has not taken the color of a decree or a deemed decree, therefore the appeal is maintainable. And that is exactly, if your lordship takes, my lord, the amicus's short notes of 3-page, lordship will find it there. Kindly, my lord, takes the note, because I have to deal with him only. My lord, at amicus, দুটো একটা নোট দিয়েছে মোটা। হ্যাঁ হ্যাঁ সব লাগিয়ে দিয়েছে, হ্যাঁ হ্যাঁ না না এই যে এরকম এইরকম না, ওটা নয়, এই যে এরকম ল কমিশন প্রথমে আছে দুটো। তো দুদিকেই তো অ্যাপয়েন্ট। ও ও এটাতে নয়। I think there is one technical issue, my lord, is that he is appointed in the other matter in good faith. So, my lord, I am relying, so my lordship will. Now, my lord kindly takes his paragraph, page 2, not numbered, but it is paragraph 2 in that page, my lord. The bill was passed, lordship has seen, my lord. না এই যে এটা তোমাদের দেয়নি, অ্যামাইকাস দেয়নি, দিয়েছে তো, এটাই দেখাচ্ছে না, আমার নোটটা দেখাচ্ছে, ল কমিশন রিপোর্ট দেখাচ্ছে। So lordship, my lord, takes his page 2.
Yes.
Second paragraph. The bill was passed in Lok Sabha without being referred to the standing committee. The bill was taken up for consideration in Rajya Sabha on 22nd December 2009, and it was observed that there was no sufficient rationale for setting up commercial divisions in high courts in India, and the bill was referred to Law Commission in 2013, and upon extensive deliberation and discussion and in-depth study, the Law Commission of India gave shape to the 253rd report. This is a report, my lord. Some of the salient features of the 2015 bill was that there will be no appeal. Kindly sees, my lord. So when the bill went to the Law Commission, already this was something which was discussed. There will be no appeal from the orders of the commercial division or the commercial courts, save under order 43 of the Code of Civil Procedure, and from final judgments of commercial division or commercial courts. Such appeals will only be jurisdictional commercial appellate court. So, my lord, as I said, when the issue went up to the Law Commission, this was already in the minds of the legislature, my lord, and the intent was very clear in the bill that there will be no appeals. The whole idea was to, my lord, cut short the entire proceedings instead of having long drawn litigations for years. Now, my lord, kindly takes the next sentence itself. The report also at page 54 suggested that the constitution of the commercial division or a commercial court should take place simultaneously with the constitution of a commercial appellate division. The commercial appellate division will hear appeal against the orders and decrees passed by the commercial division or commercial court. So therefore, my lord, it was also pointed out what appeals and orders and decrees the commercial appellate division would hear out. The commercial appellate division will not entertain any civil revisional applications or petitions against an interlocutory order of commercial courts, including an order on the issue of jurisdiction, which can be agitated only in an appeal against a decree. So therefore, my lord, if it was a decree, then therefore, my lord, that would not be looked into at all. Yes. Now, my lord, kindly sees the next line, very important. Appeals would lie only against orders enumerated under Order 43 of the CPC and Section 37 of the Arbitration and Conciliation Act 1996 and no other orders. My lord, if this rationale is to be followed, which ultimately took shape of the Commercial Courts Act, my lord, then, my lord, if lordship opens this floodgate, then it should also open for Section 37 also. My lord, lordships cannot be having, my lord, a soft heart, my lord, pardon me for using it, for people who file a suit and not for people who go for arbitrations, because nowadays arbitrations also is a long tenure affair. So, my lord, the idea was that to cut short commercial litigations, my lord, this would, and he's not remediless. Greatest of respect, he's not remediless. His remedy lies somewhere else. That is all. It is not that he's remediless. But the fact is that, my lord, to cut short the intent of the legislature was this only, that either you qualify under Order 43 or Section 37 of the Arbitration Act. Otherwise, no appeals would lie to the appellate division of the Commercial Courts Act, under the Commercial Courts Act. And this, my lord, kindly sees is the intent also, my lord, of the third paragraph which he sets out in the by the amicus. Kindly sees, my lord, the third paragraph at page 3. As would appear from clause 14 of the bill. Now, this again went to the commission. The intendment of the law commission was to provide for an appeal, my lord will kindly see, only against orders under 43 CPC and 37. There was clause 15 in the bill which provided that an appeal shall lie to the commercial division of the jurisdictional high court against every decree of the commercial division or commercial court, including a judgment on a claim. So therefore, my lord, the alternative was also suggested to the commission, which took shape, my lord, as the act today is. This was discussed. It is not that, my lord, lordship is for the first time hearing this issue. This was also discussed, my lord, whether, my lord, an appeal shall lie to commercial division on jurisdictional high court against every decree. So if it is an Order 7, Rule 11 situation, this was also discussed, my lord, that whether an appeal should lie against that or not. Now, my lord, kindly sees, he goes on to quote, my lord, Order 43 at the bottom of that page. Then kindly sees, my lord, his discussion. This is now his discussion. The amicus, page 4. There is no definition of either judgment or decree in the Commercial Courts Act. May not be, but it is guided by some act. I'll show, my lord, where the discussion is. As would appear from Section 2.2 of the Commercial Courts Act 2015, the words and expression used and not defined in the Commercial Courts Act has, my lord will kindly mark this, has to be assigned the same meaning which appears in the CPC. This is very important, my lord, because the CPC defines it. The definition of decree is provided in Section 2.2 of the Code of Civil Procedure Code. As defined, it means formal expression of an adjudication which, so far as it regards the courts expressing it, conclusively determines the rights of the parties with regard to all or any matter in controversy in the suit, and may be either preliminary or final. Now, my lord, apropos this, let us go to the CPC. Before, my lord, I show these are all expressions, my lord, of the amicus. Nothing more than that, my lord. But then kindly comes to the CPC, and, my lord, kindly takes, my lord, Section 2.2. Because I say, my lord, that puts an end which has been considered by the legislature. My lord, kindly see sections 2.2. Decree to Section 2, subsection 2. Decree means the formal expression of an adjudication, which, so far as regards the court expressing it, my lord will kindly see the words are very strong, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include, kindly will mark this, my lord, it shall be deemed to include the rejection of a plaint and the determination of any question within Section 144, but shall not include any adjudication from which an appeal lies, as an appeal from an order or any order of dismissal for default. So therefore, my lord, the exception is also carved out. And this is to be read with the Commercial Courts Act. Now, my lord, if it is, my lord, a rejection of plaint, as in our case it is, then it is taken to be a decree, a deemed decree. It is no longer, my lord, a judgment prelude to a decree, which has been argued. It has attended finality. And once it attains finality, my lord, it falls under the trappings of Section 13 of the Commercial Courts Act. And that is the legislative intent, considering the, my lord, bill, considering the Law Commission suggestions, now it is promulgated in a manner that considers all these issues and accepts that rejection of a plaint, except the, my lord, exception carved out, my lord, of an dismissal for default would be a deemed decree. Now, my lord, if it is a deemed decree, then it falls under the definition of section 30. Lordship doesn't have jurisdiction then. Kindly takes now, my lord, section 13 once of the Commercial Courts Act. Well, kindly sees any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. Any person aggrieved by the judgment or order of a commercial court at the level of a district judge, which the case is, exercising original jurisdiction, original civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order. Now, my lord, kindly comes to the proviso. Provided that an appeal shall lie from such orders passed by the commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended by this Act and Section 37 of the Arbitration and Conciliation Act 1996. Notwithstanding anything contained in any other law for the time being in force or latest patent of a high court, no appeal shall lie from any order or decree of a commercial division or commercial court otherwise than in accordance with the provisions of this Act. So, my lord, there is an exception which is also carved out in this section. No other, my lord, order, judgment, or decree can be appealed against unless it falls, my lord, under Order 43 or, my lord, Section 37 of the Arbitration and Conciliation Act. Therefore, my lord, once it is a deemed decree under Section Order 2, Rule 2, Section 2, Subsection 2, my lord, this entire exercise, my lord, of considering anything else does not appear to be fruitful because, my lord, his remedies are somewhere else. And that is exactly which is being followed by all the courts. And with deepest of respect, this has not been considered, my lord, in the judgment of Shrachi, which they are heavily relying upon. This has not been considered at all. My lord, just by merely making a sentence, my lord, reading a sentence where it is that it is maintainable will not do. It needs to, my lord, discuss the law as it is. And my lord, kindly sees, my lord, here the Act is very clear, and my lord, the section is also, my lord, very clear in CPC. And that's the exact argument being made by the amicus, my lord, is that it is still in the stage of not becoming a decree. Order 43 के तो खुलना. अजीब को तो है ना? Now, my lord, why I say this? Because, my lord, it would then unsettle the entire Commercial Courts Act. If, my lord, what is being submitted is followed, then it would completely unsettle the Commercial Courts Act. It's a very strict legislature, I find, my lord, because if I cross 120 days, I cannot file, my lord, a written statement. If I file a proceeding before a non-commercial court, which is commercial, I cannot seek, my lord, transfer of it, my lord, under section 15, because it has to be prior. And this has been followed by the courts. Now, my lord, our court, my lord, commercial court rules, which came in October 2023, also says that, my lord, if a proceeding is filed post the rules coming in, cannot be transferred. And it has to have the same fate of a rejection of a plaint, not a return of plaint. Now, my lord, if that be so, then everything would be appealable. Then it would, my lord, open a floodgate for every application or plaint which is filed, which is not maintainable under the Commercial Courts Act. The intent was very clear that you follow in toto, otherwise you fail. Now, my lord, apropos this, kindly, my lord, considers that, my lord, when it is a deemed decree, it cannot be touched. And it is, again, I'm saying, he's not remediless. And the most important part, my lord, lordship is sitting in appeal, not, my lord, in a supervisory jurisdiction. I would have understood that even if today lordships were sitting on a supervisory jurisdiction over courts, my lord, below, my lords, to see whether there was a jurisdictional error or not. This, my lord, is sitting in appeal. And with greatest of respect, my lord, will not take me amiss, but, my lord, this is not, my lord, a supervisory jurisdiction, my lord, to see jurisdictional errors. And there is no jurisdictional errors, I'll show it. But, my lord, even then, if I take it that there was a jurisdictional error, still then lordships are not the, my lord, honorable courts to decide upon this, because lordship is sitting in appeal. and the appeal is barred under a legislature because it has taken the shape of a decree, my lord. And that is the entire argument of the amicus, showing that it is still not a decree, but a prelude to a decree. It's at best a judgment, which has not taken the shape of a decree as yet. But the law is just the opposite, my lord.
What if an appeal is filed against the judgment?
If this was a judgment, definitely maintainable.
No,
If this was an order, definitely maintainable. Because in this particular matter, we have come up before my lord from orders.
Decree is the formal, final expression. Judgment is the reason or grounds.
Yes.
So what if an appeal is filed only against the judgment?
My lord, it can't be. It can be, could have been. Rather, my lord, I'm grateful for this question, my lord, which is fallen from the honorable court, my lord. It could have been if this was a judgment. But this is no longer a judgment. No longer a judgment.
Decree is supported by a judgment.
Correct. Absolutely, my lord. Absolutely.
So what
but,
if...
my lord, this has taken the shape of a deemed decree or a decree per se. So then it no longer remains a judgment. But there is a, with greatest of respect, my lord, in the CPC also, there is, this has not been defined to that extent. No act defines it in that way. Like, my lord, in the Arbitration Act, my lord, deemed award is nowhere stated. It's a deemed award. Deemed service is nowhere stated. But, my lord, by interpretation of law and the legislative intent, my lord, we have the judgment law, which has fallen from different high courts, and, my lord, the Supreme Court has taken the shape what is a deemed award, and, my lord, what is a deemed service. দেখো এগুলো তো যেগুলো আমরা দেখাবো এগুলো কারা দেখিয়েছে এগুলো এগুলো কি দেখিয়েছে আমরা দেখাবো মেইনটেনেবিলিটি অফ দি অ্যাপিল কি করে হবে নন মেইনটেনেবিলিটি হওয়া উচিত ঠিক তো কেটেছি And if your lordship, my lord, may I just interrupt? Even sees order 43, it is even more drastic. It only uses the word orders. Following orders under the provisions of section 104, namely. Thereafter, it's silent about, my lord, judgments or decrees or anything.
The decrees that the commercial courts pass, there is no appeal.
Yes, there are. There are from the commercial courts. If we follow, my lord, the act per se, then, my lord.
Mr. Banerjee, Article 136 is purely discretionary. That is not an ordinary remedy.
Absolutely, my lord.
It's very difficult to, you have to think about it.
Even, my lord, 226 is open. Even 226 is open.
Against decrees of commercial court.
My lord, if it can be argued in that manner, my lord, I'll say why. Because, my lord, if we are thinking of there is no remedy, if we are thinking there is no remedy, it's a very tall argument. But then if we are thinking there is no remedy, which is falling from my lords, is what happens, my lord, if there is a decree passed, then there is no appeal. Then, my lord, there is no remedy. A person cannot go remediless under the act. Lordship is thinking of Article 136, but then, my lord, there are other ways. My lord, if I don't have a remedy, I can always carve out a remedy by having, my lord, a tall argument maybe.
How can writ court go into factual disputes?
No, my lord, this, my lord, can be challenged, I'm saying.
My lord, may I seek one indulgence? My lord, will your lordship be taking this up, my lord, at 2 o'clock? Then I'll leave from here just now, my lord. I'll be there at 2 o'clock.
No,
For
2
15
o'clock. 2 o'clock, Mr. Pradeep Ghosh is arguing a matter.
As it is,
I
I
have promised him.
today, so
And Mr. Banerjee will not finish today, he says.
there's no chance.
My lord, I wanted to show you a Bombay judgment where again covered.
My lord, I will show at least 10 judgments, including my
Very
lord's
well, very
judgment,
well.
where it is covered.
Very well, we'll consider everything.
Very well.
As it is, as it is.
My lord, may not worry, I'll give him all sorts of judgment.
Yes,
of
yes,
all
sir.
This is,
So today, my lord, I will not.
as of now, I am sufficiently confused, so confuse me more.
So, my lord, as I say, my lord, is kindly sees, my lord, the language and, my lord, the intent. My lord, I would have understood. I am very grateful to the amicus for, my lord, providing us everything. I would have understood that this discussion was not at all considered. This was what the bill was. Exactly what my lords felt. This was sent to the commission to consider. And ultimately, which came out as the act is what actually the bill was. So this, my lord, transition we have considered, if we, my lord, take the legislative intent. And that is the reason why, my lord, the courts have become so harsh with regard to Commercial Courts Act. Because they also know that, my lord, their hands are tied, including the Supreme Court, including the last judgment, which says post X date, everything that is filed is to be rejected, unless you follow in toto. And rejection of plaint is the language used, my lord, under Order 7, Rule 11. Why I say the learned trial court has done no wrong in, my lord, when I argue on merits, I'll show has done no wrong in rejecting the plaint. Because that is the law of the land.
It was rejected by revoking 12A.
Because 12A was not followed, my lord. That is the reason.
When hey,
I can come back tomorrow even, my lord, if your lordship wants, because this is very fresh. Of course, my lord.
how long will you take roughly?
I'll take a little time because I have to
Tell
deal
us,
with
just indicate the time period.
last time, my lord, maybe
Large time.
an hour's time.
Hours time. 27th হচ্ছে সামনে। Very well. Next Wednesday, we'll keep it at 3 o'clock.
কত তারিখ?
3 o'clock, you conclude, then Mr. Shah can also start.
No, my lord will also give me a chance, my lord, in the original side matter to, my lord, conclude, my lord, for the respondents. Good faith.
For the respondent.
Yes.
Sure. Then after Mr. Banerjee, Mr.
This
Dashgupta,
would be
so that Mr. Shah can, Mr. Bagh is appearing in this matter.
But I'm the sufferer, my lord. IDFC Bank, my lord.
Oh,
My lord, we had the sufferers.
Suffer for
So they
some more,
continue, my lord. We
suffer for some more
suffering.
time. Suffer for some
There's
more.
something else which has happened, my lord. We have still not been served. I'm told, my lord, contempts have been filed against us. Although, my lord, your lordship's order that, my lord, they have to keep continuing, my lord, paying the
Very
EMIs
well,
that has
very well.
been
We
paid
know
for.
nothing of that. We have nothing before us. এটা কোন দুটো সাইডেই অর্ডার হবে? Mr. Banerjee, learned counsel, appearing for the respondent in
number 1, I think, my lord, in the yet number ta bolo. Just give
Yes,
me
he is
one.
appearing for number 1, my lord, in my
Respond number 1 in the
My
appellate
lord,
side.
in AO com number 24 of 2025.
পেয়েছো? Respondent number 1 in AO com number just বললো। Begins his argument but does not conclude. Paragraph lists these matters, lists this matter. Once again, on August 27, marked 3 p.m.
And parted, man.
My lord,
Otherwise, my lord, again we have
my lord,
to
the
start.
interim order is expiring on 25th, my lord.
On the original side or?
The
Appellate side, my lord, there is no
My lord,
original, there is no interim in original side.
Follow
My lord, in
interim
my
order
matter,
that
my
is
lord.
in operation, the interim order.
My lord,
that
I
is in
think this is a request by all. This is something, my lord,
What?
kindly make it.
Why are you worrying? Have you heard anything?
No, I have not, but if it happens, then, my lord, it would be really difficult for all of us.
No, no.
For all of whom?
Your lordships are pleased to extend the interim order for a limited period. my lord.
Yes, limited period. Till the end of this month or until further order, whichever is earlier.
Grateful.
Great. Your pleasure.
Oh, it is.
Grateful.
একটা পেন রাখবে যেটা কাজ করে, হ্যাঁ, সব পেন আছে যেগুলো কাজ করে না। কি কালি?
এগুলো বেঁধে নিস। Great.
কি? Correct, 27 তারিখে তো আসছে ম্যাটার।
For judgment, item number 1.
For the appellant, respond.
We don't know. But the proceed কোনটা? হ্যাঁ তুমি করবে
A claim as regards vehicle number 3149 and 4816 are rejected. Relevant portion of the impugned judgment is set aside. Claim as regards vehicle number 3925 is allowed. Portion of impugned judgment is upheld. Appellant Insurance Company is directed to comply with the order as above positively within a period of 3 weeks from the date of communication of copy of this judgment.
I'm grateful.
Item number 2 and 3.
I am for the respondent.
We have allowed the appeal. We have allowed the appeal. Judgment and order under appeal is set aside insofar as it holds the suit to be a commercial suit. The observations of the learned single judge in the impugned order touching the merits of the plaintiff's claim and the defendant's defense stand expunged. Make it clear that we are not deciding the correctness or otherwise of such observations pertaining to the merits of the case. We only clarify that the learned single judge hearing the suit or any application connected therewith will not take into consideration the observations in the order impugned in this appeal relating to the merits of the dispute between the parties. Having held that he had no jurisdiction, he shouldn't have made observations on the merits. That is why we have...
I understand. Because my chapter 13A application is pending. Only one request, since the order 7A, order 7 rule 11 continued for long thereafter. If a direction is given upon the learned single judge to expedite the suit, my application and the suit.
Sure.
Wait.
I was placing before your lordship the কোন পৃষ্ঠা ছিল lordship? ওই যে হ্যাঁ majority bias যে the calculation. Kindly come to volume 4, page 517 to 519. এটা দেখাচ্ছিলাম আর কি, তুমি volume 4, page numbers 517 to 519.
Yes.
Now, my lord, I'm relying upon paragraphs 115 to 121. This arose because during the course of our argument before the tribunal, I pointed out, appearing on behalf of Steel Authority, that their demands, they gave a chart. The cargo was not there for 15 continuous days. So then they revised the chart. 3 times they revised the chart. And even then they could not prove it. So my case before your lordship is this. This is showing bias, and the tribunal cannot enter the arena of conflict, or should not have. This itself is a misconduct. Now kindly, I'm not going to, Mr. Ghoshal has at that time placed it. I will, you know. I'll just go up to para 119. After all these, in 119, kindly take para 119. In the 4th case, the total amount comes to 5,983. It was 5 crores 98 lakhs something. Here, the serial number 355, dated 20th March 2012, has been excluded because that is the starting point of fortnight, which fortnight is again vitiated by non-continuity of excess cargo. Now, kindly come to paragraph 121. This again, with the change of position of the fortnight for non-continuity of the excess cargo in terms of clause 5.12, as discussed by us above. The rates as per rates are also supposed to be changed in terms of TAMP order. TAMP says apparently for the first, this is also the Calcutta Port Trust here, that for the first for 7 days you pay so much. Greater for next 7 days, the demurrage charges goes up. Then accordingly, a certain amounts is liable to be deducted from the total claim of VSPL. But as the calculation is this regard is very complicated, we would deduct a lump sum amount of rupees 40 lakhs. On what basis? Nobody, either I submitted, nor they submitted.
Why 40? Why not 30? 45.
It's nobody's case. And they are proving the claimant's case. And then they said, but as the calculation in this regard is very complicated, we would like to deduct a lump sum of rupees 40 lakhs from the claim amount. Thus, the net claim amount comes to 15 lakh 68, 19 lakh 68,000, 46,018.
19 crore.
crores. Sorry, I beg so those figures. 68 lakhs minus 40 lakhs. Considering the period taken from the date of reference, the claimant is also entitled to interest at the rate of 8% on the said sum of 19 crore 68 lakh 46,018 from the date of reference to date of the award. I'm saying that this is actually completed. This misconduct, the arbitrator showed bias, should be struck out. Last.
Sir, 1968 they deducted 40 lakhs.
Yes.
But they awarded interest on 1968.
My learned junior points out they deducted 40 lakhs, but the interest they awarded was 19 crore 68 lakhs.
Non-application of mind also.
Also non-application of mind. It's totally, this majority cannot stand, my lord. Now, next point is hey, don't copy these. I'll copy the mark. In this regard, my lord, I'll respectfully submit to your lordship at this stage that the majority did not consider the subsequent work orders dated 28/11/2013 placed by sale on. They did on BSPL. BSPL did not terminate the contract because we are the biggest customers. They wanted us. They were giving us concession. 27th May 2013, 11th May 13th May 2014, 29th May 29th April 2014. In volume 1, they kindly it's in volume 1, page 100, 106, 107, 133. Down. এত ছোট কি লেখা impossible পড়া তুই পড়ে দাও well let my junior read is too so finely printed পড়ো কত করে দিয়েছে বলে দাও
এটা পেজ 100
বলে দাও জজ
page 100 volume 1 page 100.
Kindly allow my junior to read out his very small prints, Lord.
We have noted it, 100 and then 113, further work order.
Yes.
Both we have noted.
No, not 130, 133, my lord.
113.
There's also one at 107.
100, 106, 107, 133.
And then 6 is very short, very small.
ওই দেখিয়ে 175,000 metric tons রাখতে দিয়েছিল ক্লজ প্যারাটা দেখিয়ে দাও ওটা ওইটি দেখাও না পেজ অনেক দিন রাখতে দিয়েছে আনলিমিটেড পিরিয়ড
Kindly come to page 101 once. 101.
প্যারা বলে দাও
Millard, it is a subparagraph without number. It's from the 3 paragraphs from the top. Millard, it says that sale in the event sale requires additional space. BSPL shall provide additional space to store the cargo free of cost to sale above 1,75,000 metric ton, irrespective of the time period.
So now time goes through the window in Major Port Trust Act also. Because this is their operation. They want to get back the money they have invested. Then, my lord, I will say, I request your lordship to এটা দেখো যেখানে এটা আছে আমাদের no 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 reviewটা তো give me 1 minute, my lord.
130.
Review the whole case, বলো
130 and
Yes.
page 139.
This is your lordship will find in para 31 at page in the majority award. Page 557. This is a review meeting held in terms of the STA.
The award 557. Page.
My lord, kindly make a note of it. This is para 73 of the majority award regarding the review meeting.
Para 73.
Review meeting is contemplated under clause 8 of
Page.
Mr. Bolu, Chuk Bolu. Para 73 the part. What I propose to do, my lord, next day, I shall come with all the awards in one spiral.
73 is at page 100. Page 500. 500.
দেখিছো তো ঠিক
In the volume 4.
অ্যাওয়ার্ডে দেখিছো তো
Award.
দাও আমাকে ঠিক আছে রিভিউ মিটিং এর ক্লজ 8টা দাও
মিটিংটাই 130
ক্লজ 8 বলা দরকার আছে ক্লজ 8টা এটা তো আমি জানি ক্লজ 8টা বার করে স্টিয়ার if your lordship takes, I'm sorry to trouble your lordship, kindly take volume 1, page 89. Review.
Right.
Yes.
Return report হবে আসবে হবে পাবো তৈরি করেছিস কত বলবো
SAIL and VSPL agree that for the first 6 months of operation,
page 81.
No, page 89.
Yes.
Clause 8 below review. SAIL and VSPL agree that for the first 6 months of operation of this agreement shall be treated as a test period to make an assessment of the actual quantity of cargo that can be made available to VSPL terminal and to test the operational parameters, after which, this is important, terms of the terms will be reviewed jointly, and if required, terms and conditions will be further revised. Here was an opportunity for them to say, please add demurrage under clause 5.12. And this review meeting took place not after 6 months, in October 2009, after 1.5 years. When the claim demurrage is from May 2000, May 2009, no? May 2009. At that time, they were already charging us. They didn't send us any letter or notice. So this, but how has the tribal majority dealt with it, my lord? I'll read only one paragraph. To my mind, my lord, my submission was to the tribunal was that having known that they have the right to charge so-called demurrage, having not done so, they had waived their right. Then, kindly see, it is also argued on behalf
This is award, majority award,
Not
paragraph,
only, yes.
paragraph.
Paragraph 73, my lord, which is at page, page 500. What volume? Volume 4.
Yes.
Volume 4, page 500. It is also argued on behalf of the respondent in the review meeting as provided in clause 8 of STA. The claimant never raised the question of payment of demurrage. On the other hand, the claimant accorded incentives to the respondent by lowering the rate from 167 as mentioned in ITSC. It is also argued on behalf of the respondent that such incentives, rebates given by the claimant to sale because the sale was the biggest customer of the claimant. This was not denied by the learned advocate of the claimant. Learned advocate for the claimant has drawn our attention to the provision of clause 8 of STA and tried to impress upon us that the purpose of review was only to assess the actual quantity of cargo that can be made available to VSPL terminal to test operational parameters, after which terms will be reviewed jointly, and if required, terms and conditions would be further revised. Learned advocate for the claimant further argued that sitting in the review meeting had not exonerated either of the parties for payment of contractual dues, which is again supported by statutory dues fortified by TAMP order. To our mind, the stand of the claimant in this regard appears to be acceptable. My argument is one side, it is going in another side, and they are saying it's acceptable. Below this, I mean, it's hit by, I know that tribunal can always interpret a term of the contract, but it is so unreasonable, it's hit by Wednesbury principle. And that is also within the, it's against public policy. It is so unreasonable. That's also covered by the Supreme Court judgment.
Whose judgment was it? Do you remember? Wednesbury, 1946. Who would be there in 1946?
Oh, many of them.
Wilberforce, no.
Wilberforce.
Diplock, maybe? No, Diplock was later.
Later on. Diplock came later on. They earned 50. Diplock, Devlin, and the Ds. 3 Ds.
Your junior has found out.
By Lord Reed.
Lord Reed.
Reed.
Lord Reed.
আর কি ছিল?
সব সবার কোন বেরিয়ে গেছে।
House of Lords নাই? Atul?
Not Kaku.
Kingsbay.
No, Mashi.
Kingsbay.
Well, my Google is the
Kingsbay. তারপর যায়নি ওপরে? House of Lords যায়নি?
1948, Volume 1, King's Bench, page 2.
Only Lord Reed.
Huh.
See, the Jaiswal has gone up further.
Lord Reed, Somerville, and Singleton.
That's a Court of Appeal then.
It's authored by
Lord Reed, Lord Justice Somerville, and Lord
Singleton.
Lord Singleton.
Lord Justice Somerville sitting in House of Lords.
No, they were all the Court of Appeal, not Justice. They were
It's Court of Appeal.
Lord Justice Singleton's book were all given etiquette at the bar. Whenever you are called to the bar, a copy was given free of charge.
I see. Yes.
Lord Reed was in trial court, yes. Now we'll kindly take para 74. The respondent also wanted us to invoke the principle of waiver against the claimant, and this was argued by the claimant did not raise any question of demurrage in the review meeting, and therefore VSPL waived the claim of demurrage. This again, it was argued that although no notice of 30 days, my argument was only on the question of review meeting, 30 days as contemplated in clause 5.12 was issued to sale, not buy, for storing excess cargo. VSPL went on storing, it is other way around, excess cargo while refusing to store such excess cargo. We would like to quote the exact. No, I don't wish. I don't want to trouble you, Lordship. Nothing turns on this. So, Miller, it is hit by this. Next point, Miller, I argued last time was regarding review next to diversion of vessel. Yes, diversion of vessel. Same page, Miller, same page. Take para 72, last few lines. Of majority judgment. Second line, Miller, from the top. Now, I'll read the whole paragraph, Miller. Otherwise, it will not be right. Too longish. Oh, God. Kindly come to आगे para 72 को आरंभ होइছে বলো তো page 499 Miller, para 72 starts. It was further argued on behalf of the respondent that the behavior and dealing of the claimant is self-contradictory. The claimant all along insisted on more cargo and ships in the port area, and at the same time, the claimant went on charging of demurrage. In this connection, learned senior Mr. Ghosh has referred to page 177 of SOD, item number 110, and 279 of C series, 284 and 285 of R series, and page 303 of C series. It was pointed out by him that from page 177 of SOD that on one hand, the claimant resisted diversion of MVPX, and on the other hand, they are charging demurrage at page 212 of C series. Similarly, Mr. Ghosh referred to page 179 of Statement of Defense of C series, charging demurrage from the respondent. In reply to this argument on behalf of the respondent, Mr. Suvensu, learned advocate for the claimant, has referred to some of their letters appearing at page 283, 284, and 285 in our series by the respondent, and submitted that as minimum guarantee of the cargo was not fulfilled by the respondent, the claimant resisted the diversion of vessels. This is totally well, then they say in this document art series, the last 4 lines, and submitted that as minimum guarantee of cargo was not fulfilled by the respondent, the claimant resisted diversion of vessel. It's totally wrong. They had everything in the hand, the majority. They should have rejected the submission when writing the award. It appears from the letter of the claimant at page 283 of art series in respect of diversion of vessels to Gangavaram port. The claimant wanted to place it on record. The diversion of the vessel was in deviation from clause 1.2a, 4.1, 4.5, and 4.8 of STA. In other two letters, the claimant apprehended causing huge loss for the diversion of the vessels. Clause 1.2a of STA speaks about assurance of 1.5 million metric tons as per annum to VSPL berth for a period of 3 years from the date of signing. Other clause, as mentioned in the letter, also deals with the volume of extended cargo. It is the universal. Now, so far, 1.5 million minimum, we have exceeded much more. Then, last 4 years. It is the universal practice of business. The parties involved in commercial transaction will always look forward for more and more profit. Full stop. There come any dispute. Then comes, my lord, and in doing so, this is coming from the adjudicating authority, if there appears any violation of the agreement inviting penalty and demurrage, the same cannot be avoided or denied. And demurrage comes out of so-called out of sales pocket. And this cannot be a pronouncement of an adjudicating authority. And so far the universal practice is concerned, there is no evidence. It is not even argued by any party. There's no evidence. We're led by VSPL. Regarding 40,500 square meters of land dedicated to respondents' cargo, my lord, we will, that's at page 558 to 560. দেখো ভর্য বার করো volume 5 ভর্য দাও
single arbitrator award.
আমি জানি তুমি আমাকে এটা দাও 40,500 মেজরিটি কোথায় ডিল করেছি সেইটি দাও কোথায় ডিল করেছে দেখো না বলো প্লিজ কোন প্যারাগ্রাফে This one, give me 1 minute, my lord.
Eight.
Okay. Philip, page, paragraph 88, phone page
504.
504.
Page
Philip,
500.
Page 504. Which volume?
Volume 4. Volume 4.
Well, clause 3.3 has been set out just above that in end of clause para 87. Clause 3.3, capacity. Based on the minimum discharge rate of 20,000 metric tons per day, the berth can handle cargo volume up to 4 million metric tons approximately 210 to 220 days in a year. The cargo volume of 1.5 million metric tons spread over 12 months period can be comfortably handled with adequate buffer provided for maintenance, possible bunching of ships and breakdowns, including force majeure situation. Therefore, VSPL warrants that the cargo assurance by sale to VSPL of 1.5 million metric tons on a year-on-year basis during the agreement period of 4 years can be easily handled by VSPL. Now it has been underlined by the majority. VSPL confirms that 40,500 square meters of area will be utilized for handling the cargo and mechanized handling facilities, drains, roads, railway tracks, buildings, amenities, and other systems associated with providing integrated terminal service as per this agreement. 88. It is visibly clear from the above accepted provision that the entire 40,500 meters of area assured to be utilized for rendering integrated terminal services in a custom bonded area consisting of various structures in the expression terminal. What is more significant, the claimant on this clause has confirmed 40,500 meters of area would be utilized for the cargo. This is for entirely dedicated to sales cargo. They cannot say for during the operational period, no, PPT has got something to say. VSP TAMP has got something to say. This is area dedicated to sales cargo. And you charge me whatever you want to charge me. This one, I come to show you, Lordship, the minority award. There was an LTA before this, STA, where it was incorporated, and they said in unequivocal terms that an area of 81,000 square meters would be utilized for sales cargo as per that agreement. That I shall come when I come to the minority award, my lord. Well, so far, this is what I argued last time, my lord. I don't think I can go anything any further. Now coming to the minority award, my lord, kindly take the minority award. Why? It is more wholesome, and the learned trial judge rather accepted this award. Kindly take the minority award.
Page 526.
Volume 4.
Volume. Volume 5.
Volume 5. Volume 5. Volume 5. Will kindly come to 533 to 537. After setting out what we have pleaded, what are contentions from paragraph 12. Respondent filed a statement of defense and an application under section 16 of the 1996 Act and pleaded that tribunal has no jurisdiction. The dispute fell within the jurisdiction of TAMP. In reply, claimant objected to the same on the ground that TAMP only fixes scale of rates and the dispute in question does not fall within the jurisdiction of TAMP. TAMP is not empowered nor authorized to decide any matters arising out of a private contract tribunal upheld the contention of the claimant. It's a private, then they don't know on which boat to sail. Once it is stamp and MPT, on the other side it is private contract. But if it is BOT, of course, on the operational base, they ought to get the money back, and they went into private contract. Then, on merit, respondent, the STA was for a period of 3 years, and it was extended for 1 year. Thereafter, fresh agreement was entered into between the parties, valid till 31st March 2014. I've shown you, Lordship, for greater amount they allowed us to store without any demurrage, without any period, as long as I required it. Then, kindly come to Millard, page, paragraph 13, middle of it. Millard, moreover, parties intentionally, as your Lordship got it, intentionally did not incorporate the term demurrage in the STA for stacking the cargo beyond 60,000 metric tons or beyond free period. Further, as per Article 1.1 of STA, cargo imported by respondent was to be handled by the claimant from unloading to transportation of the cargo from hook point to stockpile area and reclaiming the cargo from stockpile with shore handling system. Respondent never agreed, nor such clause was incorporated in STA, and respondent would pay demurrage. That respondent would pay demurrage for stacking cargo in excess of 60,000 metric tons beyond free period. It is a further case of respondent that before entering into STA, protracted negotiation took place between the parties. At the time of arriving at the rate for rendering service, the claimant was aware of import of coking coal / metallurgical coke by the respondent. For handling the cargo, including storing of the cargo for committed quantity of 1.5 million metric tons per annum. No clause was incorporated in STA, as in that case and in case the cargo exceeds the volume as mentioned in Article 5.12, demurrage would be charged. Article 1.1 of the STA lays down the responsibility which the claimant was to discharge. Article 1.2 deals with the responsibility of respondent. Article 3.3 deals with the capacity based on minimum discharge. Further, vide clause 3.3, claimant confirmed that 40,500 meters of area would be utilized for handling the cargo of the respondent as per this agreement. This area had been earmarked and has been continuously used by the claimant for handling the cargo of the respondent, for which payment of lease rental was being charged. Any correspondence prior to entering this agreement is of no consequence. Parties in this case are governed by short-term agreement. Article 3.3 confirms area of 40,500 having been marked for the cargoes of respondent. Before entering the long-term agreement, by letter dated 17/12/2003, Exhibit C5, according to the claimant, it was clarified that no specific area was earmarked for respondent. But claimant has overlooked that in spite of this clarification, Article 3.4 of LTA, which was executed on 17/12/2003, it was confirmed that an area of 81,000 square meters would be utilized for handling of the respondent cargo. Well, these are all our submissions, all my review and everything. Now kindly come to the decision. Kindly come to paragraph 19. Issues have been set out. Para 21. The articles of so far, capacity and all these articles have been set out. From our review meeting up to Article 8, that is from the STA. all the clauses. Then relevant provisions of Major Port Trust Act has been set out. Para 22, I've already read out, this was a private contract. They rejected my application. Issue number 2 was regarding limitation. That was also rejected by the tribunal. Kindly see regarding rake movement. She has dealt in detail, everything in very great detail. So far as para 25, providing of rakes is concerned, as per STA Article 4.10, dispatch instructions with the responsibility of sale, respondent. These are to be furnished by respondent 7 days prior to commencement of any particular month for the rake movement plan, for which for such month at the rate of 2 rakes per day. Such rake movement plan was to not exceed loading of more than 5 rakes on any day. On the basis of these instructions, claimant was to place the wagon indents, forwarding notes with VPT Railways as per instructions of respondent on day-to-day basis. From the documentary evidence placed on record, it is clear that the claimant at no point of time complained to the respondent that it had not submitted the rake movement plan. In all the letters relied upon by claimant, there is no mention of violation of Article 4.3, 4.5, 4.5, 4.10, and 4.11. It had in fact been blaming VPT Railway for diverting the rakes or non-supply of rakes, placing of wagon intents and forwarding notes as per Article 4.11 and 5.15 was the responsibility of claimant. Respondent, like claimant, could only request these authorities. Rather, with the email dated 11/9/2010, it was respondent who complained to claimant that for the last 2 days, no rake was dispatched from his terminal. Following the emails dated so many emails, again complaint was lodged, followed by email dated so and so. At the instance of claimant, respondent took steps in approaching VPT Railways to provide more rakes. At least 2 rakes must be provided. Reference in this regard to be made to the mails dated 2011-2010, C48, C36, and there are many letters and emails on record. In none of the letters the claimant ever mentioned that the respondent had breached these terms of the agreement. The only grievance expressed by the claimant was against VPT Railway Authority for diverting the rakes or not providing the rakes. From the reading of Exhibit C25 to C50, it can be seen the claimant did not blame the respondent. It was their duty. We have given them the indent. Then we'll kindly take page para 27. Claimants, para 27 minute. Claimant's contention that since Section 48 of the Major Port Trust Act permits levying of demurrage, stamp notification issued from time to time would automatically apply to this contract. Provision of the Port Act stamp permit charging demurrage as a deterrent from longer stay of cargo at the terminal strengthen the contention of Mr. Counsel for the claimant relied on the decision of Port of Madras versus Amin Shah Tiari Lal, Board of Trustees for Bombay versus Jai Hind Oil Mills, and Board of Trustees for Port of Bombay versus Indian Goods Supplying Company. Relying on these judgments, counsel for claimant contended that congestion in the ports affects the free movement of ships and essential goods. Ships, like wagons, have to be kept moving, and that can happen only if there's pressure on the importer to remove the goods from the boat's premises with utmost expedition. Therefore, the authority has a right to charge demurrage in order to ensure quick clearance of cargo. There is no quarrel with the proposition of law, but we cannot lose sight of the fact that in the above cases, Apex Court was dealing with issues arising out of Major Port Trust Act and not out of private contract. In the present case, parties are to be governed by private contract. Hence, none of these cases reliance by claimant are of no help. Yes. Now, so this is it. But it is also same thing in Calcutta port. If a person is importing cargo, it will be in the import manifest of the vessel. Import manifest is settled with the master of the vessel to the port authority. There's so much, A has so much cargo, B has so much cargo, C has. C, say, appoints a stevedore or clearing agent to clear the cargo. Cargo is cleared for either ship's derrick or the shore vessel on the in the port premises. The stevedore or the clearing agent brings the lorry, clears the cargo. The cargo is kept in port premises, not in a particular stackyard. And the person takes away, the clearing agent takes away the cargo upon payment of the charges. That is a procedure even in Calcutta port. Once this is done, because they'll give his manifest and they'll take it away. He's shown judgment which belong to importation by a private party, nothing to do with BOT contract or leased out place or licensed place. I said, there's no quarrel. This is all straight and simple importation by a private party through the port. Then, this being a private contract between two parties, terms and conditions of stamp as such would not apply automatically to the private contract. If claimant was interested to charge demurrage, it ought to have incorporated the same in the agreement. In fact, claimant, while entering into this agreement, consciously did not incorporate charging of demurrage. When rates for stacking of cargo were suggested in this case, claimant did not estimate any income from demurrage, and that is why it did not form part of ITSC annexure FSTA. Claimant had intentionally not incorporated demurrages because it had charged higher rates for stacking of respondent's cargo, which fact is clear from answer of claimant to a query raised by TAMP, appearing in the order dated 15th March 15/3/2005 at something of page serial number 4, page 98, volume 1 of claimant's document. There, claimant admitted that demurrage income was considered nil. This was done because claimant wanted to earn more revenue through the respondent. Once the provision to charge demurrage was consciously not provided in the contract, by implication, demurrage cannot be made applicable by relying upon 48 subsection 1 subsection D of Major Port Trust Act. TAM can only fixes the scale of rates had demurrage been incorporated in this agreement. Then for the rates claimed, claimant could rely on the scale fixed by TAMP. Claimant in no uncertain terms admitted this fact while answering query to TAMP as mentioned above. Arbitrators are creatures of contract. They can neither travel beyond the terms of the contract nor incorporate in it which is not there. You can't rewrite. This is exactly what I said. It must be under section 28(3) within the four corners of the agreement. Then the learned counsel for the claimant relied upon 42 and 48 of Major Port Trust Act. There. This has also been dealt with by the learned judge. Kindly take the following page. Last 4 lines of the paragraph. Similarly, for wharfage and storage, if demurrage of goods does not find mention in the private agreement between the parties, then the question of claiming demurrage at the scale of rates framed by TAMP would not arise. Admittedly, ST is a private contract between VSP and SAIL, and TAMP is not the authority to decide dispute like the present between the parties. There is no provision in the agreement regarding payment of demurrages in case of respondent SAIL keeps its cargo for a longer period beyond the free time prescribed in Article 5.12 of STA. To my mind, all terms and conditions TAMP mutatis mutandis will not apply to this private contract. Parties are bound by the terms of the agreement, that is STA. By implication, provision of TAMP cannot be attracted nor apply, particularly when claimant itself decided not to estimate its income arising out of demurrages while fixing rates under ITSC Annexure 1. This find mention in response given by claimant to a query raised by TAMP. It appears in TAMP's order dated 15/3/2005 at page 98, item 4, volume 1 of claimant's document. TAMP's query was, she quotes unquotes, the reason for not estimating income from demurrage charges. To this claimant's response was, quote unquote, since major portion of storage will be used on rental basis, income from plot rental has been taken into account. It does not desire expect the cargo to remain in the transit area beyond the free period, and hence demurrage income is considered nil. Again, this is really a repetition. I will not. Kindly come to the next following page, end of para 29, last 8 lines of para 29 of minority award. Claimant's subsequent conduct also show it was not to charge demurrages. If the claimant was to charge demurrage, it would have find mention in review meeting as well as in the letters and emails sent by claimant. However, we find no such reference to any of the communications till December 2010. The reason is not far to find as to why demurrage was not incorporated. The apprehension of the claimant that if we did so, it would suffer revenue loss. Next paragraph. The claimant is afraid of losing revenue. Therefore, insisted SAIL should not divert its vessel, though on the day Exhibit R11 was issued by claimant. Ground stock was 85,099, but still claimant insisted SAIL not to divert its cargo. Diversion of cargo was protested not because the respondent did not fulfill the committed quantity, but to ensure that it does not lose revenue. Claimant in the letter of R11 stated diverting the vessels to Gangavaram would cause huge revenue loss. In the Exhibit R12, in order to handle SAIL's goods, vessels refused vessels of others so that there would be no hindrance to SAIL's vessel operation. VSP also pleaded that in case SAIL divert its vessel, VSP would lose out on revenue from SAIL as well as from others. This act of claimant is clearly indicates that there was no scarcity of space and that on account of stacking SAIL goods, claimant did not suffer any loss. Desire to earn huge revenue appears to be the reason to forego charging demurrage from SAIL under Article 5.12. Article 5.12 is in 2 parts. First part provides stacking of 60,000 plus 30,000 for a period not exceeding 15 continuous days, and it will be subject to 30 days notice. In the second part, there is no requirement of notice. In case cargo is expected to go beyond 2 million metric ton storage, it will be organized by claimant, that is 90,000 with further provision for 30,000 of coal in exigencies for a period not exceeding 15 days. Per clause 8 of the agreement review meeting, it was held, instead of being held in the first 6 months as per terms of the contract, it was held 1.5 years, that is on 5/10/2009. Purpose of review. নোটিশ এসে গেছে রেডি আছে আমি আমাদের বন্ধ করতে পারি
3টে বেজে গেছে
ঠিক আছে
3টে
এই যে এটা করে দিচ্ছি রিভিউ মিটিং শেষ করে দিই as per purpose of review was to make an assessment of the actual quantity of cargo that the respondent was to make available to the claimant and also test the operational parameters. And terms were also to be reviewed. In that meeting, claimant agreed to give concession of rates expecting huge quantity of respondents' cargo to be stacked. As per claimant's own showing, overstacking of cargo was from as far back 4th May 2009, but not a word was uttered in this regard in the review meeting held on 5/10/2009. Well, I can skip the following few lines. Kindly come to the middle of the page. Since the claimant knew that levy of demurrages was not part of the contract, hence it did not mention the same. By its conduct, claimant waived his right and therefore it stopped from claiming the same now. In this case, claimant had been stacking cargo for 60,000 and 30,000 and because of lack of notice. By its conduct, claimant waived his right of 30 days prior notice before making arrangement. Let's not. The most important part is, my lord, kindly come to this portion before I stop, my lord, for today. Then I shall come back to it. This is most important, which I want to show your lordship. Short.
Paragraph 40.
Paragraph 43. Well, you kindly come to paragraph 43. And I shall stop after this. Paragraph 43.
516. Page 569.
Volume
5.
Yes. You kindly come to page 569, paragraph 43. It would not be out of place to mention in the proceeding held on 19/12/2014, claimant filed a chart showing cargo handling during the period May 2008 to 5th May 2009, May 2009 to 5th May 2010, May 2010 to 5th May 2011, May 2011 to 5th May 2012. If we see the chart as filed by the claimant, it is clear that for the period 2008 to 5th May 2009, respondent had supplied a quantity of 0.97 million metric tons of, it will be million metric tons. As per agreement, respondent was to supply in the first year of contract a quantity of 0.75 million metric tons. Therefore, claimant has rightly shown that they were not to claim any demurrage. For the period 2009 to 2010, claimant's own showing, the respondent had supplied 1.94 million metric tons. For the period 2010, May 2010 to 5th May 2011, claimant had shown the respondent supplied a quantity of 2.06 million metric tons. For the period May 2011 to 5th May 2012, quantity of 1.86 million metric tons. Applying the second part of clause 5.12, which says if the cargo was expected to go beyond 2 million metric tons, then the limit would be 90,000 plus 30,000, that is 1,20,000 metric tons. Therefore, for the period 2009 to 5th May 2010, when the quantity delivered was 1.94 million metric tons, it was expected to go beyond 2 million. For the period May 2010 to 5th May 2011, actual quantity was more than 2 million metric tons. Therefore, these periods also limit the purpose of counting of overstacking, or overstacking ought to be limit prescribed in the second part of clause 5.12, that is 1,20,000 metric tons. If we see the statement filed by the claimant on 19/12/2014, in none of the lot respondent exceeded this limit. In fact, claimant had completely ignored second part of clause 5.12. We never kept 1,20,000 metric tons for a period of 15 days. Never. Similarly, for the period May 2011 to 5th May 2012, the quantity delivered by the respondent was 1.86, which we call expected to go beyond 2 million. Maximum limit was 90,000 plus 30,000 for the period of 15 days. Claimant has not taken note of these aspects and the provisions of contract, therefore wrongly levied demurrages. Well, I should come back to one or two other points which she has dealt in great detail, my lord, and majority is totally silent. Even the appellant during the course of his argument did not refer to this chart.
When we want to come back? This is non-commercial.
Non-commercial.
Tomorrow there is a possibility, because tomorrow it's appellate side first.
Yes,
but appellate side lists are not very long in our court. Let it run. Let it remain in the list.
Yes.
Rekhe dao list. Mr. Ghosh.
Only difficulty, my lord, is from 1st to 5th of September, my lord. I do not know if it will be continuing till that long, my lord. 1st to 5th, I am not in India, my lord.
So it may conclude next week. If not this week, then on next Wednesday, definitely.
Tomorrow I shall finish the trial court judgment also, if I get the opportunity.
If it is taken.
And the next day I show the judgments.
Mr. Ghosh, Kamalan, senior counsel representing the respondent, resumes his argument but does not conclude. Paragraph lists the matter once again. Kalke date dido. Comma retaining its position.
I'm sure it will not be before 11:30, my lord, tomorrow.
Sorry?
I'm sure it will not be before 11:30.
No.
Not before 12, I believe. Not.
Because with my
may not be called on at all. এই দাঁড়াও।
Item number 12.
Wait, please, your lord.
Appearing on behalf of the respondent.
20 minutes, Mr. Chatterjee. Today 20 minutes.
Well, let us see whether some progress can be made. Let two. To refresh your lordship's memory, Miller, the point which I was arguing is whether the learned judge could have passed the impugned order sitting in the non-commercial division in respect of a suit which was filed long before the coming into force of the Commercial Courts Act and which stood transferred admittedly under Section 15
on the coming into force of the Commercial Courts Act, because the subject matter was a commercial dispute as defined in the Commercial Courts Act. And Millard, I was trying to persuade your lordship to hold that by reason of considering my application for extension to file the written statement in the non-commercial division in respect of a suit which stood transferred to the commercial division, the learned judge did not and in fact could not advert to the provisions of section 15, particularly section 15 subsection 4, which was very necessary and very material in the context of an application for extension of time to file written statement. And I was placing, Millard, on the last occasion, the provisions of section 15. Millard, may I, Millard, draw your lordship's attention once again to the provisions of section 15 once. Then I will go to the judgments, Millard, of 3 division benches of 3 different high courts, which have construed section 15(4) in the context of filing of written statement and in the context of a suit which stands transferred from the non-commercial division to the commercial division, and held that in such cases, the court has to consider, it has the discretion, it has the power to consider grant of a fresh period for filing of written statement, whatever may be the other provisions of the court. Millard, for your lordship's convenience and subject to my lord's sanction, Millard, I have tried to put the relevant provisions of law which we will have to consider and which have been considered by the judgments which I'm going to cite in, Millard, a short tabulation. The books are there, but Millard, for the sake of convenience, Millard, I have tried to put the relevant provisions in one place. Section 15, Millard, is the key section which has to be taken into account. Section 15, subsection 1, all suits and applications, including applications under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of a specified value, pending in a high court where a commercial division has been constituted, shall be transferred to the commercial division. Millard, we are covered by this provision because it was a suit which was pending in the High Court prior to the enactment of the Commercial Courts Act, and therefore shall, because it is a commercial dispute, admittedly, it shall stand transferred to the commercial division.
What was the nature of the dispute?
Millard, it is an intellectual property dispute. So obviously, Millard, it comes with in the definition of commercial dispute. Now, Millard, the subsection 2 deals with a case where a suit is pending, a similar provision, where a suit is pending before the district court and on constitution of the commercial court after the enactment of the act stands transferred to the commercial division. Our suit is not really concerned with that, although, Millard, the 2 provisions are parameteria, 15(1) and 15(2), dealing with 2 categories of suits, one pending in the High Court and the other pending in other courts. Subsection 3, over the page, Millard, page 2 of the tabulation which I have given, subsection 3, where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures that were not complete at the time of transfer. So, Millard, the question of written statement was not complete at the time of transfer because on the enactment of the Commercial Courts Act, it stood transferred and the application for extension of time to file written statement was pending. So, the issue of written statement was not complete at the time of transfer. Now, more important, Millard, is subsection 4. Millard, the underlining and highlighting is done by me for emphasis. Subsection 4. The commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may be necessary for a speedy and efficacious disposal of suit or application in accordance with order 15A. There's a slight mistake, 3 and width have to be deleted. Order 15A of the Code of Civil Procedure 1908. Provided that, this is important, that the proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure 1908 shall not apply to such transferred suit or application. Then, the next words are important. And the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. This is a very important provision, and the decisions which I am going to cite, turn on this part of Section 15, subsection 4. And it has been held that this part is a special provision which prevails over other provisions in the matter of filing of written statement in a suit which stands transferred and in which written statement has not yet been filed. I'll come to the judgments. For convenience, I have extracted the provisions of Order 5, Rule 1, Sub-Rule 1, which are not to apply by virtue of the proviso to Section 15, subsection 4. As Order 5, Rule 1 said that when a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of summons on that defendant, provided that no such summons shall be issued when a defendant has appeared at the presentation of plaint and admitted the plaintiff's claim. Provided further that when the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. Sorry.
Yes, Mr. Chatterjee.
Yes. Now, this provision, which I have extracted, has been omitted by reason of the proviso to Section 15, subsection 4, so far as a commercial suits in the commercial division is concerned. Now, subsection 5, in the event that such suit or application is not transferred in the manner, we are not really concerned with that. If it is not transferred, then there will be an order for transfer, etc., etc. Section 16. This is important. Amendments to the Code of Civil Procedure 1908 in its application to commercial disputes. Subsection 1. The provisions of the Code of Civil Procedure 1908 shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner as specified in the schedule. The commercial division and commercial court shall follow the provisions of the Code of Civil Procedure 1908 as amended by this Act in the trial of a suit in respect of a commercial dispute of a specified value. Where any provision of any rule of the jurisdictional high court or any amendment to the Code of Civil Procedure by the state government is in conflict with the provisions of the Code of Civil Procedure 1908 as amended by this Act,
the provisions of the Code of Civil Procedure as amended by this Act shall prevail. Now, my lord, the amendments, if your lordship turns over the page, are contained in the schedule, and I have extracted the relevant provisions. Now, my lord, first of all, in the first schedule to the code, that is, my lord, the Code of Civil Procedure, in the order 5 in Rule 1, Sub Rule 1, for the second proviso, the following proviso shall be substituted, namely, provided further that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing, and on payment of such costs as the court deems fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. Then, Miller, there is an amendment in Order 8 also, which is relevant. In Rule 1, for the proviso, the following proviso shall be substituted, namely, provided that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing, and on payment of such costs as the court deems fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. Then, Millard, there is an amendment in Rule 10 also, by adding a proviso, provided that no court shall make an order to extend the time provided under Rule 1 of this order for filing of the written statement. Now, Millard, these are all the relevant statutory provisions in the context of the matter which I am arguing. Millard, now I will come to the judgments where the three different high courts have held that these provisions, these amendments in the Civil Procedure Code, which now instead of 90 days provides a period of 120 days from the date of service of summons, even those provisions are not applicable for a suit which stands transferred under Section 15. They will apply to suits which, Millard, have been filed after the coming into force of the Commercial Courts Act, while determining within which period the written statement has to be filed. In the context of a suit which stands transferred, because of the provisions of Section 15, subsection 4, expressly vesting a court to which it stands transferred, namely the court in its commercial division, with a power to prescribe a new timeline for filing of a written statement, this bar of 120 days does not apply in respect of such suits. In fact, in one of the judgments, before the Andhra Pradesh High Court, reliance was placed on a Supreme Court judgment. I have that judgment also, SCG Contracts Limited, which had proceeded on the basis of these provisions and said that very well it stands extended from 90 to 120 days, and therefore you have to file within 120 days. Well, at the High Courts, while considering the judgment, held that the Supreme Court was dealing in that case with a suit which was filed as a commercial suit after the commencement of the Commercial Courts Act. And therefore, the 120 days will apply in that context. But the Supreme Court had no occasion to take into consideration the provisions of Section 15, subsection 4, because the Supreme Court was not dealing with a suit which stands transferred under Section 15. A very, very long judgment of the Andhra Pradesh High Court, followed by Madhya Pradesh High Court, followed by Telangana High Court, and then there is a judgment of a learned single judge of our court, that is for persuasive value. I shall now straight away, pass on to the judgments. I shall now straight away pass on to the judgments.
You cite one of them today, then we'll stop.
Uh,
There's a 3:30 matter.
Yes, Millard, in that case, I was submitting because Millard, I want to cite the judgments on the same day because there is some link between them.
Then
So,
next day.
We will start next.
लिखे now, Mr. Chatterjee, learned senior counsel. Mr. Chatterjee, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph. Let it run in the list. Or are you in difficulty tomorrow or
No, I am in some personal difficulty tomorrow.
next week?
Next Wednesday, Millard.
As requested by him, let this matter be listed again on Shamner Budbare date diye dao, retaining its position.
Retaining is. In fact, Millard, if I get about an hour somehow, Millard, I think I'll be able to not only make
Your
substantial progress but conclude.
Let us see.
3 years, Millard, there is no written statement.
How many years?
We are arguing
23 years.
23 years.
We are arguing that point. We are arguing a question of law.
Lord, I am Millard into profession in 23 years. Perhaps Millard, Millard and my Lord Justice Rai, Millard, we are in the profession for 23.
23 years.
23 years. 2000, Millard. 2001, we all came, Millard.
Millard, and recently I heard an expression used in the Supreme Court where the judges are referring to in the context of the stray dogs case. They are saying that, no, you are referring to anecdotal evidence, which means not evidence placed in a legal or Millard, out of a research. So I think, Millard, these facts are anecdotal facts.
Call the matter.
330 matter. Item 88 to 94 part.
My senior is appearing online.
Who is your senior?
Mr. Orindam Paul. Mr. Orindam Paul.
Orindam?
I have made my submissions on the sections. And section 434, I have submitted to your lordship that after considering the provisions of this section along with the rules and regulations which have been formulated, it gives the court a discretion in the matter of transfer. It is not that only because, my lord, NCLT has been formed, therefore mandatorily they will be able to have transfer. That is not so. Even though, my lord, the provision of section 434C is in mandatory language. And your lordship has been pleased to ask me that what are the interactions of the main provision of subsection C if read along with the provisos. Well, I've got this submission to make, that kindly take, my lord, section 434 once more, 434C. I am not going to repeat my submissions on this.
একদম নিচে আছে, এটা আমি হাতটা মুচকে যাবে না।
Well, your lordship will be pleased to see the 434C originally that was that came into effect on the 15th of December 2016, and the provisos, they came subsequently from time to time. Well, I say that, well, this is called maturity of legislative wisdom. That's all that I can say. Your Lordship sees, my lord, the first proviso for provision of subsection C is in mandatory language. All proceedings under the Companies Act, including proceedings relating to arbitration, compromise, arrangements, and reconstruction, and winding up of companies pending immediately before such date before the district judge, district court or high court shall stand transferred to the tribunal, and tribunal may proceed to deal with the such proceedings from stage before such transfer. There was only one proviso in 2016, the first proviso, provided that only such proceedings relating to winding up of the companies shall be transferred to the tribunal that are at a stage as may be prescribed by the central government. This was the only proviso that was there. Second proviso was added, inserted on 15th December. The first one, the main provision of subsection C was in 7th December 2016. The second proviso came into existence on 15th December, 7 days thereafter. The second proviso was inserted. Your Lordship will please to see the footnote. Provided further that only such proceedings relating to cases other than winding up, for which the orders for allowing or otherwise of the proceeding are not preserved by the High Court, shall be transferred to the tribunal. My lord, the first proviso itself watered down the mandatory language of the main provision. Then second proviso further watered it down. And third proviso, that came, my lord, on the 29th of June 2017, which is almost 6 months after the second proviso. And third proviso says, provided also that, I am not troubling your Lordship with I, the II is the proceeding relating to winding up of the companies which have not been transferred from the High Court shall be dealt with in accordance with the provisions of the Companies Act 1956. So, my lord, further dilution of the main provision with regard to, my lord, the mandatory nature of the language.
Not really. It says the ones which have not been transferred. It doesn't say which have not been transferred, meaning the first proviso.
So this, my lord, came when, my lord, the first one was the main provision was enacted. This was not in the mind of the legislature. So, my lord, this second proviso came, my lord, and it said that the proceedings related to winding up which have not been transferred, then, my lord, this was done. Then, my lord, the fourth proviso was inserted on 29 June also. Then, my lord, came the last proviso, which was inserted on 6 June 2018. And that said, my lord, that provided further that any party or parties to any proceeding relating to winding up of the companies pending before the court immediately before the commencement of the Insolvency and Bankruptcy Court may file an application for transfer of such proceeding, and the court may by order transfer such proceeding to the tribunal, and the proceedings so transfer shall be dealt with by the tribunal. Now, my lord, my submission is this, my lord, that so far the fifth proviso is concerned, that is the last proviso. The two points I have raised in this, that it has to be by a party, any party or parties to the proceeding shall have to, my lord, apply. He had that such kind of a party may file an application. My first submission is that my learned friend's client had not been a party, having been.
You have shown us those orders of these.
Those orders. I am not going to trouble your lordship. And the second submission I wanted to make before lordship is such proceedings and the court may by order transfer. A discretion has been given to the court. So the court may or may not, depending upon, my lord, the stage at which, my lord, the proceedings have reached in the High Court. If it is found, my lord, that the proceedings have reached such a stage which cannot be reversed, then, my lord, the High Court will continue to have it.
Yes.
Well, my submission is this, that this section, subsection C, will have to be read along with the proviso. The section itself, this entire section has to be read together. Provisos, the purpose of this proviso is to give a complete picture of the main provision. This is what, on this, my lord, I do not know whether your lordship, my lord, needs any authority to be cited. My lord, I found a few judgments, my lord, if I may
please
just show to your lordship. My lord, first one I wanted to rely upon is a House of Lords decision. This is reported in 1940 appeal cases, page 206, Jennings versus Kelly. Copy আছে?
(1948).
1940. The House of Lords decision, consisting of Viscount Mom, each has given a separate judgment, but saying the same thing in different language. Then Lord Atkin, my lord, I agreed with whatever just Viscount Mom has said. Then Lord Russell of Killowen, separate judgment, and Lord Wright. Well, here the controversy arose by reason of the language in the proviso which was given. If your lordship kindly comes to page 213 straight away. Section 9C is the subject matter of controversy. And this, your lordship, will please about the middle of this page, where, my lord, it is said that it will be desirable to set out in full the terms of section 9 subsection C. And section 9 subsection C has been set out. I just show your lordship, my lord, the controversy here. Section 9C, my lord, kindly see, where owing to an increase of not less than 25% of the population, according to last census, there is growth or an extension of any city. My lord, kindly mark the word, any city or town. There is growth of an extension of any city or town, and the licensing authority is satisfied after hearing any evidence tendered to it by any resident or owner of the property in such city or town that the restrictions in this section on the granting of license may be relaxed. The licensing authority may grant license to any applicant, notwithstanding that the same would be otherwise forbidden by this section. After this, the proviso has been added. Provided that, and this is what created the confusion, provided that such license shall be granted only for premises situate in the ward. Now, my lord, kindly mark the word or district, electoral division, in which such increase of population has taken place, and in substitution for at least 2 existing licenses held in respect of the premises. I am not troubling your lordship. My lord, what happened, what is the controversy is this, that in the main provision, the growth or extension of any city or town. And my lord, in the proviso, it is the granted only for premises situated in the ward or the district electoral division in which such increase of population has taken place. So the controversy arose, my lord, the confusion arose, I should say, whether it is increase in population in the city or in the ward and a district. This was the controversy. Now, this, my lord, came to be discussed by the court. My lord, kindly come to page 214, last paragraph. The main point is that, and this is Viscount Mom's judgment, the main point is that of the true construction of section 9, subsection C, which I have set out above, it is clear from the words of the proviso that the license can only be granted if there had been an increase of not less than 25% of the population of the ward. I will omit the words or district or electoral division for the sake of brevity. in which the application for license is being made. It is also necessary that a second condition as to the population should be satisfied, namely that there must be an increase of not less than 25% population of the city or town. Is it also necessary? It's in the form of question. Is it also necessary that a second condition as to the population should be satisfied, namely that there must be an increase of not less than 25% of the population of the city or town? And then, my lord, it has gone on to explain what it actually meant. Your lordship will kindly come to my lord, the next page, page 216, second paragraph. Or I should say, my lord, kindly come to the last sentence of page 215. Why then provide that the growth or extension must be due to the increase in population of the same area? And then it is saying, we must now come to the proviso, for there is, I think, no doubt that in the construction of the section, the whole of it must be read and a consistent meaning, if possible, given to every part of it. I am relying upon this. And then it has gone on to say, kindly come to page 217. I am not troubling your lordship with the entirety of it. I should say, my lord, in the second paragraph at page 217, the last 10 lines. The words are the curious phrasing. Page 217, second paragraph, 10 lines from the bottom, or say 12 lines from the bottom. The curious phrasing of the section and the reference to the necessity for the growth or extension of the city or town suggest the necessity for an explanatory clause. And reading the whole section together, it seems to me far easier to accept the view that the increase in population mentioned in the first lines of the section is an increase in the population of the ward. So, my lord, the proviso is being taken into account for the purpose of explaining the meaning of the main provision, as indicated in the proviso by the words, etc. And then, my lord, kindly come to page 218. Second paragraph. In my view, that is not the case here, as the Lord Herschel has pointed out in the same case. Of course, a proviso may be used to guide you in the selection of one or other of two possible constructions of the words to be found in the enactment, and show when there is doubt about the scope, when it may reasonably admit of doubt as to its having this scope for that, which is the proper view to take. My lords, that is precisely the method of construction which in my view is applicable in the present case. I will add that the words beginning provided that are, in my opinion, additional and explanatory words necessary for the purpose of giving more definite meaning to the preceding words. That is, of removing doubt as to its scope, and they might easily have been incorporated in the earlier part of the section at the risk of making it rather more cumbrous than it is. So, my lord, proviso has been made to give, my lord, make the main provision simpler. So, instead of putting it along with this, along with the main section, my lord, by way of a proviso, it has been put for removing any doubt. And then, my lord, we are not making it rather cumbrous than it is. Then it says, it cannot, I think, be disputed that in construing a section of an Act of Parliament, it is constantly necessary to explain the meaning of the words by an examination of the purport and effect of other sections in the same Act. A number of striking examples can be found. Then, my lord, next page 219, the last sentence of that paragraph, after quoting from Maxwell, there can, I think, be no doubt that the views expressed in Kent's commentaries on American law, cited with approval in Maxwell as correct. The true principle undoubtedly is that the sound interpretation and meaning of the statute on a view of the enacting clause saving clause and proviso taken and construed together is to prevail. This is what it says. The similar, my lord, are the views of my lord, Lord Russell, the next one. And my lord, I'm not troubling your lordship. Lord Wright also said the same thing. My lord, I'm not troubling your lordship with this. So this is the first, my lord.
I would have thought you would have placed the judgment of Lord Wright as the only right view.
My lord, the Lord Wright's right view is my lord, confirming the views expressed by Lord Moore, Viscount Moore. My lord, this is of course a judgment of the of English court. My lord, I would request your lordship, my lord, to look in this connection. I have got, my lord, the two authorities on this one. I don't know to what extent I will be in a position to place it. My lord, one is Craze statute laws. I have got the 7th edition. I'm sure my learned friend has got a later edition. Lordship, I'm going to do a copy. My lord, Craze, which is 7th edition. 7th edition, page 218. Page 218. Lordship will take construction of provisos. This is page 218, construction of provisos. The effect of an accepting or qualifying proviso, according to the ordinary rules of construction, is to accept out of the preceding proportion of the enactment or to qualify something enacted therein, which but for the proviso would be within it. And such a proviso cannot be construed as enlarging the scope of an enactment when it can be fairly and properly construed without attributing to it that effect. When one finds a proviso to a section, said Mrs. Lush in so and so, the natural presumption is that but for the proviso, the enacting part of the section would have included the subject matter of the proviso. In West Derby Union versus Metropolitan Life Insurance, Lord Watson said, I am perfectly clear that if the language of the enacting part of the statute does not contain the provisions which are said to occur in it, you cannot derive those provisions by implication in the proviso. When one regards the natural history and object of the provisos and the manner in which they find their way into Act or Parliament, I think your lordships would be adopting a very dangerous and certainly unusual course if you had to import legislation from a proviso wholesale into the body of the statute, although I perfectly admit that there may be and are many cases in which the terms of an intelligible proviso may throw considerable light on the ambiguous import of the statutory words. Lord Herschel said in the same case, I decline to read into any enactment words which are not to be found there and which would alter its operative effect because of the provisions to be found in any proviso. Though he admitted that a proviso may be a useful guide in the selection of one or the other of the two possible constructions of words in the enactment or to show the scope of the latter in a doubtful case. Then Mrs. Moulton's, the fallacy of the proposed method of interpretation is not far to seek. It sins against the fundamental rule of construction that a proviso must be considered with relation to the principal matter to which it stands as a proviso. It treats it as if it were an independent enacting clause instead of being independent of the main enactment. The courts, as for instance, in ex parte so and so, have frequently pointed out this fallacy and have refused to be led astray by arguments such as these, which have been addressed to us, which depend solely on taking the words absolutely in their strict literal sense, disregarding the fundamental consideration that they appear in the proviso. Then, my lord, so was section 65, the group sections, etc. My lord, I'm not troubling you, lordship. Then, my lord, kindly come to construction of repugnant provisos and saving clauses. It sometimes happens that there is a repugnancy between the enacting clauses and the provisos and saving clauses. The question then arises, how is the act taken as a whole to be construed? The generally accepted rule with regard to the construction of a proviso in an act which is repugnant to the purview of the act is that it laid down and as laid down in Attorney General versus Chelsea Waterworks, namely that where proviso of an act of parliament is directly repugnant to the purview, the proviso shall stand and be a repeal of the purview, as it speaks the last intention of the makers. It is the last intention of the makers. And in our case, it is more clear because the proviso came afterwards. In point of time also, it is the last. Where there are two sections dealing with the same subject matter, one section being unqualified and the other containing qualification, effect must be given to the section containing the qualification.
কবে lay down করেছে দেখে না 1731.
In fact, my lord, I will submit, my lord, it is not repugnant. It is, my lord, really to some extent mollifying the rigors of the main provision. Where it was, my lord, that it shall stand transferred, the proviso says, no, it shall not stand transferred unless the court directs it to be so. The court's discretion has been given. The mandate, the legislative mandate is not that it must be transferred. The legislature subsequently had left it to the discretion of the court for the purpose of coming to the conclusion, looking at the facts and circumstances of the case, whether it is transferable or not. This will be my respectful submission before your lordship. Well, similar is the provision with regard to in Benian also. I don't want to trouble your lordship, my lord, with details of it. This is, my lord, Benian second edition of statutory interpretation. If I may hand up to your lordship copy and want to my copy. So crazy. It হচ্ছে Benian.
Okay. আর ক্রেজ তো
Resam dini?
না বললো দেবে না
সে কি? কখনো সার্চ করি না without I'm sorry, I'm ডাইনি যখন আমি জানতাম না। ওরা দেবেই বা কি করে আমার কাছে পড়ে আছে।
anything ক্রেজটা better.
Well, this is Benian.
Only thing I want to point out, my lord, your lordship will find, my lord, that the present editors, my lord, I think the one of Craze is better, my lord.
That's it. You know, what's Cambridge in the Oxford? Crazy zoo. I see.
Crazy Cambridge and
It's this last in bracket, that's what matters.
At the moment he stood up, I knew that one such is coming.
So more reliable, crazy would say.
But crazy is crazy.
Lord, we'll just come back, my lord.
My lord, I will just take your lordship. My lord, I don't want to trouble your lordship with the entirety of it. Kindly, my lord, come to the third page of this, of the one that I have handed up to your lordship, which is page 494 at the bottom. After, my lord, giving all these examples, this is second paragraph. It says, while the substance of this dictum, your lordship has got that.
Yes.
Well, the substance of this dictum is undoubtedly correct. The treatment of the proviso as qualitatively different from the rest of the section is not. The entire section, including the proviso, is an operative component of the act. I am relying upon this. Judges used to cast doubt on the value of a proviso in throwing light on the meaning of the words qualified by it. This is because proviso, like savings, were often put down as amendments to the bill by their opponents and accepted to allay usually groundless fears. Thus, this still happens in the case of private bills, but since the establishment of the Parliamentary Council Office in 1869, it has not been true of the Public General Act. Then, my lord, in the case of precision drafting, the proviso is to be taken as limited in its operation to the section or other provisions in it qualifies. Where the act is the subject of disorganized composition, what is in form a proviso may be in fact an independent substantive provision. The proviso is then said not to be a true proviso. Tomorrow, in our case, I personally feel that what has happened is this, that in course of time, by reason of my lord, discussions, debates, etc., these provisions are being improved upon.
Would have been so much clearer if they had amended the main provision.
Main provision.
These doubts wouldn't have been there.
Exactly. Then, my lord, I wouldn't have to place before your lordship craze or mania. My lord, now, my lord, coming back to our country, my lord, if I may just draw your lordship's attention, and this is, my lord, the main judgment. This was given by a bench of 3 judges of the Supreme Court as early as in 1985. And, my lord, there it has summarized the law. So I just placed that paragraph. This is reported in 1985, 1 Supreme Court cases, page 591. This is the judgment of Sundaram Pillai versus Pattabhiram. This is reported in 1985, 1 Supreme Court cases, page 591, paragraph 43. Kindly straight away come to page. The page is written, my lord, in small letters at the top, page 22. Paragraph 43. After, my lord, discussing various judgments on this interpretation of proviso, at paragraph 43, the Supreme Court has summarized. Your lordship has got that. We need not multiply authorities after authorities on this point, because the legal position seems to be clearly and manifestly well established. So, to sum up, a proviso may serve 4 different purposes. 1, qualifying or accepting certain provisions from the main enactment. This is the usual thing, my lord, we know. Then 2, it may entirely change the very concept of the intendment of the enactment by insisting on certain mandatory conditions to be fulfilled in order to make the enactment workable. This is the second one. Third, it may be so embedded in the act itself as to become an integral part of the enactment and thus acquire the tenor and color of the substantive enactment itself. So, my lord, this also comes to our aid. And fourth one, it may be used merely to act as an optional addenda to the enactment with the sole object of explaining the real intendment of the statutory provision. So 3 and 4 both perhaps I can take advantage of. And my lord, so what was really stated earlier at the first instance, at the first flush, the legislature thought that all should be shall stand transferred. But gradually, my lord, it had been realized that it should be left to the court depending upon the facts and circumstances of the case. And this is what, my lord, the judgments also say. So, my lord, I just conclude my submissions, my lord, on my part, my lord, by citing two decisions, my lord, which all of us very frequently refer to and rely upon. This one is, my lord, Action Itpath, and the other is, my lord, Navin Chandra. My lord, Action Itpath is reported in 2021 two Supreme Court cases 641. My lord, after discussing various judgments and provisions, my lord, earlier, this is Mr. Justice Rohington's judgment. Page 654, paragraph 7, section 434 after amendment has been set out. And my lord, this is the original one. I am not troubling your lordship with this anymore. Kindly, my lord, come to the gradual transition had been recorded in subsequent paragraphs. I am not troubling your lordship. Kindly, my lord, come to, yes, this judgment, paragraph 11 at page 656. In Forex judgment, this court, and that is, my lord, 2024 Supreme Court cases, paragraph has been quoted. After setting out the aforesaid rules and the fifth proviso to section 434(1)(c, then held, we are of the view that rules 26 and 27 clearly refer to a pre-admission scenario, as in the clear from the plain reading of rules 26 and 27, which make it clear that the notice contained in forms number 6 had to be served in not less than 14 days before the date of the hearing. Hence, the expression was admitted in form number 6 only means that notice had been issued in the winding up petition, which is then fixed for hearing before the company judge on a certain day. Thus, the Madras High Court view is plainly incorrect, whereas Bombay High Court view is correct in law. Then the resultant position, and this is what, my lord, is the finding. The resultant position in law is that, as a first step when the code was enacted, only the winding up petitions where no notice under Rule 26 of the Companies Court rules was served were to be transferred to NCLT and treated as petition under the code. However, on a working of the code, the government realized that parallel proceedings in high courts as well as before the adjudicating authority in the court would stultify the objective sought to be achieved by the court, which is to resuscitate the corporate debtors who are in the red. In accordance with the objective, the rules kept being amended until finally Section 434 was itself substituted in 2018, in which a proviso was added by which even in winding up petition where notice had been served and which are pending in the high courts, any person could apply for transfer of such petitions to NCLT under the code, which would then have to be transferred by the High Court to the adjudicating authority and treated as an insolvency petition under the code. This statutory scheme has been referred to, albeit context of so and so. Then, my lord, it goes on. Caledonia has been considered in paragraph 13, and then paragraph 14, my lord, the summary has been made at page 659. Paragraph 14 says, what becomes clear upon a reading of the three judgments of this court is the following. 14.1, so far as the transfer of winding up proceedings is concerned, the court began tentatively by leaving proceedings relating to winding up of the companies to be transferred to NCLT at a stage as may be prescribed by the central government. Then 14.2, this was done by the Transfer Rules 2016, which I have placed before your Lordship. This was done by the transfer, which came into force with effect from 15/12/2016. Rule 5 and 6 referred to 3 types of proceedings. Only those proceedings which are at the stage of pre-service of notice of the winding up petition stand compulsorily transferred to NCLT. So pre-notice period. 14.3. The result therefore was that post-notice and pre-admission of the winding up petition, parallel proceedings would continue under both statutes, leading to a most unsatisfactory state of affairs. This led to the introduction of the 5th proviso of section 434(1)(c), which, as has been correctly pointed out in the Caledonia, is not restricted to any particular stage of the winding up proceeding. This is very important. 14.4. Therefore, what follows as a matter of law is that even post-admission of a winding up petition and after the appointment of a company liquidator to take over the assets of the company sought to be wound up, discretion is vested in the company court to transfer such petition to NCLT. Clear? Therefore, this concept of mandatory transfer goes into the background. So, my lord, this becomes a discretion vested in the company court to transfer. The question that arises before us in this case is how such discretion is to be exercised. Then, my lord, it goes on to consider various provisions, and ultimately, if your lordship comes to paragraph 25, and this is, my lord, creating another set of problems as to what is actually is meant by this. Kindly, my lord, come to paragraph 25. Given the aforesaid scheme of winding up under chapter 20 of the Companies Act, it is clear that several stages are contemplated, with the tribunal retaining power to control proceedings in a winding up petition even after it is admitted. Thus, in a winding up proceedings where the petition has not been served in terms of Rule 26 of the Companies Court Rules 1959, at a pre-admission stage, given the beneficial result of the application of the court, such winding up proceeding is compulsorily transferable to NCLT to be resolved under the court, that is pre-service of notice. Then even post-issue of notice and pre-admission, the same result would ensue. However, post-admission of a winding up petition and after the assets of the company sought to be wound up become in custodial leases and are taken over by the company liquidator, Section 290 of the Companies Act 2013 would indicate that the company liquidator may carry on the business of the company so far as may be necessary for the beneficial winding up of the company, and may even sell the company as a going concern, so long as no actual sales of the immovable property or movable properties have taken place, nothing irreversible is done, which would warrant a company court staying its hands on a transfer application made to it by the creditor or any party to the proceeding. It is only where the winding up proceedings have reached the stage where it would be irreversible. My lord, kindly note, where it's reached a stage where it would be irreversible, making it impossible to set the clock back, that the company court must proceed with the winding up instead of transferring the proceedings to NCLT, to be decided in accordance with the provisions of the court. Whether this stage is reached would depend upon the facts and circumstances of the case. So, my lord, entire thing comes before your lordship. There is nothing mandatory now. So, my lord, your lordship, now, my lord, I respectfully submit to your lordship, if your lordship looks into the sections, the provisos, and read this judgment, my respectful submission is, your lordship will have to consider whether an irreversible stage has been reached or not. If irreversible stage has been reached, then, my lord, your lordship should retain the jurisdiction. If not, transfer it there. And this, there, my lord, I respectfully submit that wide range of discretion has been given to your lordship, depending upon the facts and circumstances of each case. So, my lord, each case has to be decided on its merit. But in this connection, my lord, I interject by saying that, subject to correction by my learned friend, well, I have not come across this. A situation like ours, I have not come across. A situation where, my lord, a winding up petition admitted, the parties came before the court, lodged their claims. A person came and offered to my lord under section 466 for the purpose of, my lord, paying off the dues. Substantial amount has been paid, which I shall again, my lord, refresh your lordship's memory by showing. Substantial amount had been paid to the creditors. 3 of the winding up petition had been disposed of because, my lord, the creditors have been paid. Workers have been substantially paid. They are happy. Only a balance amount is due and payable, which we are agreeable to pay. The situation is this: the official liquidator had been directed to take possession and, my lord, to make over possession to the person who has made this application, my client, under section 466. In a situation like this, I just wonder, and then, my lord, in the meantime, for the purpose of protection of the property, my lord, the security guards have been appointed. Substantial amount of money has been paid by the creditors on behalf of the creditors, as also by my client. Now, my lord, I respectfully submit, if your lordship wants to set the court clock back, how will it be done? This is a question, my lord, I'm asking myself. I don't find any answer, because, my lord, the money has gone out. These creditors are satisfied; they're gone. My learned friend's client, who was a creditor, had deliberately, voluntarily stayed out of it. Said, I don't want to have anything to do with it.
Is that the kind of irreversibility that the Supreme Court has in mind?
Your lordship will decide.
Possibly, anyway, yes.
Irreversibility, my lord, I submit to your lordship, that is the kind of irreversibility.
Irreversibility, as prima facie as it appears, is where in no way the company can be revived any further. Assets have been sold, things like that.
My submission will be this, that today, let us look into this from this point of view, the issue of irreversibility. The point is, what is the meaning of irreversibility? That means, my lord, the position cannot be reversed back. My lord, today, if my lord, at the initial stage, the matter had come before the NCLT, then, my lord,
you are concerned about the money that you have paid.
Not only the money I have paid, my lord, I am interested, my lord, what is the purpose of NCA, my lord, this IBC? For the purpose of revival of the company. I am here to revive the company. And for that reason, my lord, I have paid these amounts of money. Had it gone before, my lord, the NCLT, under the IBC code, then, my lord, the committee of creditors would have been formed, COC. They would have, my lord, sat together for the purpose of deciding as to how it is to be, the debtors are to be paid, what is the proportion of the amount, how the debtors are to be got rid of. And then, my lord, new person would have been invited for the purpose of buying the property, buying the company, taking over the company. A new entity would have come in for the purpose of taking over the company. This is exactly what this court is doing. This is exactly what, my lord, before Mr. I.P. Mukherjee. This is exactly what was before, my lord, the division bench, my lord, presided over by Mr. Shonji Banerjee. And this was the endeavor which was there. This was the effort. These were the efforts which were being done. And in pursuance of those efforts, my lord, I have come into the picture. Why should I be, my lord, turned away from the door? Why should it go before, my lord, the COs? What will happen to the workers? I do not know. What will happen, my lord, with regard to the money I have spent? I do not know. Whether the money will come back to me. And, my lord, your lordship has seen how, my lord, the monies are paid. If it is 80 lakhs of rupees due, 4 lakhs of rupees is, my lord, is being decided by the COC in their meeting to be paid to the creditor. And the creditor is being paid for a chicken feed and asked to go away. And that becomes binding upon them by reason of, my lord, the statutory provision under the IBC.
You are one of the promoters of this company?
No, I was one of the contributors of the company who has come forward for the purpose of reviving the company. Well, I am submitting to your lordship today, when your lordship is looking into the matter, your lordship is deciding not only the facts of our case. Your lordship will be deciding with regard to, my lord, the future things, my lord. Some kind of a guideline will have to be given.
The assets and properties in whose custody? The company's assets and properties, OL?
Yes, OL is there, my lord. I am, my lord, in possession, in the sense that the OL has been directed to give possession to me in terms of the order of Mr. I.P. Mukherjee, which I showed to your lordship. I shall place it before lordship. Now, my lord, the properties are in custodial leases. My lord, I submit to your lordship, my lord, it is not that anybody is running away with the property, because it is still lying in the custody of the court, this court. The question is, should it go before that court? I say, my lord, let it remain in this court, because this court had taken the trouble of passing all these orders from time to time.
Mr. Mitra, you may be absolutely right in saying that this court has a discretion now, not a question of mandatory transfer.
Yeah, absolutely.
Now, this judgment also, to some extent, indicates how that discretion is to be exercised. Because that was one of the questions posed by the learned judge, Justice Nariman.
In the facts and circumstances of that case.
Correct, correct.
But again, it says that upon the facts and circumstances of each different case, every case cannot be the same. So, my lord, your lordships, my lord, are not to exercise discretion on the basis of the discretion exercised by court X, court Y, and court Z.
Correct, correct.
So, the facts of this matter will have to be taken note of. And, my lord, kindly take, again, I just remind your lordship, my lord, take the paper book once. Page 177. Volume 2. Page 177.
Yes, we remember about 60 lakhs you had paid. Something like that.
Yes, about 60 lakhs. And there is no winding up petition pending now. In the normal course, if this IBC code had not come into existence, by this time the company would have revived and started working. By reason of the litigative processes, the whole thing is being delayed.
How much is due to, according to Mr. Mukherjee's client, how much is due to them?
400 and something or odd, 400 and something crores. And, my lord, they have gone before the, my lord, they are proceeding independently. They are not.
One thing I want to indicate,
yeah.
My lord, the very judgment my learned friend cited said that the intention of the provisos was to prevent, my lord, parallel proceedings before two forums. Now, my lord, what is irreversible has also been indicated. I have, my lord, gone, I have a right, my lord, to go, my lord, before, my lord, the adjudicating authority, which I have done.
NCLT.
Yes. Now, my lord, in that case, it cannot continue for even 1 day. And I had moved the application, my lord, for, my lord, transfer.
We'll hear you.
Yes, my lord, and one other thing, my lord, which should be indicated to your lordship. My lord, this, my lord, reason for not wanting to go, my lord, before, my lord, the adjudicating authority is, my lord, under their watch, my lord, winding up, they failed to pay, my lord, the dues which resulted in winding up. Account became an NPA. Therefore, they are ineligible to be a resolution applicant there. And here, my lord, there are 3 attempts which have been made to have, my lord, a 466 without following. And I'll point out, even one criteria required to be fulfilled for a 466.
And this is coming from a person who wanted to stay out of.
My lord, I have
go
to
and go and
no,
pursue
correct,
your-
correct.
go and pursue
My
your
lord,
remedy
staying
elsewhere.
out, my lord, staying out is, my lord, absolutely consistent, my lord, with my prayer.
Yeah, let us
I'll
see.
start, my lord, with, my lord, our Supreme Court and, my lord, our Madras High Courts. I don't even have to, my lord, go, my lord, beyond, my lord, the shores.
My lord, we shall definitely see, my lord, how to what locus standi they have. Definitely, I shall take in. Went to the DRT for the purpose of pursuing their claim, abandon these particular proceedings, and thereafter moved an application under section 7 of the. Well, my learned friend is talking about our conduct. What about their conduct? Going from the forum shopping, going from one forum to another forum.
My lord, one is for recovery, the other is for revival.
I know what it is all about. We know all about it. You deliberately abandoned the winding up proceeding. You said that I don't want to stay there. I want to recover my dues.
Outside winding up, specific.
Ask 26, ask 20. Next Tuesday?
Next Tuesday?
Tuesday, 3:30? Mr. Mukherjee, Mr. Banerjee?
Lordship, sir.
Everybody?
I am appearing for one of the appellants. Now, my grievance is the proceeding before the NCLT is proceeding because in absence of an order of stay. Lordship, my 93 is my appeal, Lordship.
What, you want us to stay the NCLT proceedings?
Yes, Lordship, at least,
Thank you.
Lordship, at least that the next statement is deferred, Lordship, that every day, Lordship, the matter is being taken up.
Day-to-day basis is being taken up.
Every month, Lordship, it is being taken
I said every day. Now you say every month.
Apologize. I didn't mean to say every day, but
Mr. Mitro, Commander, এই আগের অর্ডারটা দেখুন না সেম অর্ডার হবে খালি হবে ম্যাটার বি লিস্টেড হচ্ছে না তো কি দেখলে তুমি এতক্ষণ ও ওদের হচ্ছে না
in my appeal, Lordship, there was a suo motu stay, Lordship. There was no application made. Transfer, suo motu transfer.
Next, how roughly, we don't want to rush you at all. Roughly, how long will you take?
I thought that I should be able to come since my learned friend is interjected. I will take some longer time than. I shall answer the questions my learned friend has raised, thankfully.
28th August. Then it is 28th.
28th, my lord, is
28th at 12:30.
28th, my lord, is
Thursday.
On Thursday. Thursday, my lord, kindly do not keep it, my lord. Thursday, I've got some problem. Small problem.
Next volatile.
Your lordship wanted to have it Tuesday, my lord. Tuesday is
Tuesday, they are not available.
My lord, morning session, my lord, if it's possible.
Booked.
তুমি কি থাকবে না?
No, my lord, my learned friend will take, my lord, that session, so let it happen.
When?
My lord, Tuesday, my lord.
Tuesday.
Yes.
Tuesday, how long should we keep for you?
Presence, that's all.
How long we should keep for you?
So long as he is not here.
Serious.
If absent, I shall continue.
No, Tuesday, they are not available at all, Mr. Mukherjee and Mr. Banerjee. So you can conclude your submission.
Yes, I conclude myself.
That's why we are asking how long we should keep.
3 o'clock, your lordship.
1.5 hours. Or 3:30. 3:30.
Very well, my lord. The moment your lordship's patience comes
No,
to an
it's
end,
not
I
a
shall
question of
say,
patience. Other matters are there. That's why. 3:15.
Very well.
But 3:15. Tuesday, one shall be.
It's a different appeal, Lordship. It's not the same appeal as my learned senior friends.
Yes.
The difficulty is, Lordship, it was a suo motu transfer, Lordship. I never made an application for the transfer of the proceedings, Lordship. And since
We are considering that very question in all the appeals.
One matter to list.
I just saw
Action.
Chalo.